Paid bill of I have to mention one item, pending item, my lord. IA in criminal number, case number 964/2025. Can it be taken bail matter? Can it be taken on 26th, madam?
You
After tomorrow,
pray before registry.
madam.
Pray before registry.
Please.
The registry will fix the date. There are many courts taking bail matters.
Similar prayer, madam. Bail application.
Similar order.
Your Lordship,
Yes.
we have already on an interim. The matter was listed on 23rd. The matter came also, but as the court was,
You are on interim.
yes.
No urgency is there.
What?
There is no urgency.
There is urgency because after 23rd only, we got the interim. So we will let the matter be fixed tomorrow, Your Lordship, or on Friday.
Interim was not extended. Okay,
For tomorrow?
okay.
May it please your lordship. Lordship, with regard to item number 50, lordship, can it be taken up at 2, lordship? On the last occasion, it was not listed. Urgency is there, lordship, because the revision is filed against the order of an appellate court.
No, not true. As
That's the last item also,
as
lordship.
per CRATM, it would do injustice to other items which are listed above you.
Lordship, NBW has been issued against him, lordship.
We'll see whether it
He has
is.
already paid the amount, lordship.
It is item number 50.
Lordship, he
It
has already
may-
paid the amount,
It
lordship.
may reach,
Lordship.
not at 2. We will not break the CRATM.
Lordship, on the last occasion, it was ought to be listed on motion column,
You
lordship.
are not understanding what
You are
I'm
not-
saying.
Oblige, your
May it
lordship.
please the lordship. I prayed for the listing of a criminal appeal which is listed yesterday, but yesterday was closed. And lordship,
Pray before registry.
lordship, actually, I am on previous bail and it is still 710. And it's only 3 years conviction, lordship.
710 means
The next date for appearance is 710, lordship. In the vacation time.
okay to be listed by the registry in any court which is taking up the same roster.
Lordship, actually, we only have been convicted for the 3 years and.
I have allowed you
Okay,
your petition.
okay, not your place.
May it please the lordship. Lordship, by recommendation for listing of an IA, lordship, which was listed yesterday, lordship, for convention delay against while preparing an appeal or revision, lordship. The matter could not be because due to the holiday, lordship, matter was not.
You have to pray before registry.
Lordship, some urgency is there, lordship, because
I may allow it, it will not reach. If we fix 100 cases,
yes, lordship.
it
that is-
will not reach. So registry knows where to list it. There are many courts taking up same roster.
But lordship, this matter was already heard by your lordship on earlier occasion.
It is part heard.
Not part
It
heard
is not
because-
part heard. It may
because
be
the
listed.
respondent had not appeared on the.
It may be listed before any court.
Oblige.
Putul. Amar kiman list. Listen kiman list. Yes.
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 At least
For listing, you request before registry.
regular bench. Really,
Tomorrow by registry. Go before registry. For listing, you pray before registry.
it's a special bench. The special act is there. Special act, my case. Yeah, not.
After puja vacation.
After tomorrow.
You don't understand English. Then
Oblige.
for listing, you pray before registry. There are many courts which are taking up additionally same roster. The registry would accommodate all of you.
My prayer is before your lordship that one IA lordship, I have filed for correction of order, bail order.
My order
My lordship. So can it be
Okay.
taken up tomorrow, lordship?
tomorrow.
Oblige.
My prayer is listing for after vacation, lordship.
No urgency after vacation,
After, because whole pending matter, lordship, 2018
but pray before registry for listing after vacation.
after vacation.
May I-
Petitioner appears will receive by this honorable court lordship. But in his appearance, police arrest him regarding the same subject matter lordship. Day after tomorrow lordship kind.
Okay.
I'm obliged.
May I please, your lordship. Lordship, my matter, I have already approached the registry lordship. Matter was listed on 23rd. Urgency is that
When
lordship,
have you approached registry?
lordship about 1 week before lordship and matter.
Approach today. Go before registry today.
I think one clarification lordship. The matter is pertains to extension of interim lordship. My
Which court passed the order?
lordship, earlier court number on 23rd, 7 lordship, it was for 4 weeks. And now trial court directed me to produce a fresh order lordship. 15 days time was granted.
Pray before registry.
My simple grand lordship. Yesterday, my case was listed.
Registry will reallocate it within remaining 2 days. You pray before registry. If registry refuses your prayer, then you may come to this.
Today also.
May it please, your lordship. Your lordship, I'd
I'll
like to
leave it
mention
on.
for listing of an IA criminal, your lordship, if Friday, lordship, because if the matter is not taken up, your lordship, my entire criminal petition will be infructuous, your lordship.
Pray before registry.
My lord, please, my lord.
Pray before registry. If registry refuses,
My lord.
if it cannot allocate to any of the benches, then
My
you
lord.
may mention it.
I may mention it tomorrow, your lordship.
Okay.
Obligation.
May it please, your lordship. Lordship, I'm praying for listing of a bail matter, your lordship. It was filed in the last week, on last Friday, your lordship. But till now, it has not been listed, your lordship.
There must be some defect
No, your lordship, we have checked.
tomorrow.
Oh, my.
Well, I think in respect of item number 37, I have been told that the case diary is not available.
Item number 37.
Yes, it is not available. Is an interim.
I am an interim. my lord.
After-
Heard Mr. T. Chakravarti, learned counsel for the petitioner. Also heard Mr. K. Parashar, additional public prosecutor, who prays for some more time for production of the case diary. Prayer is allowed. Let this matter be listed on 31st October. The interim order shall continue till next.
I'm obliged.
Prayer for listing of a revision petition against concurrent findings. my lord.
Listing, pray before registry.
I beg to mention item number 11, yesterday is court number 14 lordship. Today is the 60 days complete lordship. Earlier was rejected, court number 14 lordship. Lordship kindly,
Before court number 14 is set.
Yesterday, we have to make a mention memo then before ST.
today is 60 days completed lordship.
Pray before registry. The registry will allocate.
11.
Item 3 for withdrawal.
Where are you withdrawing?
It has been settled.
Settled. Okay, heard. Miss S. Nazneen, learned counsel for the petitioner. Also heard Mr. R. D. learned counsel for respondent number 2. Learned counsel for the petitioner prays for allowing the petitioner to withdraw the instant criminal petition as the matter has been amicably settled between the parties. Considering the grounds shown by the learned counsel for the petitioner, the prayer is allowed. This case is this criminal petition is dismissed on withdrawal.
For
None has appeared for the
For withdrawal.
petitioner on call. This matter is and there is no prayer for withdrawal. This matter is dismissed for non-prosecution.
motion be item 5.
May I please, your lordship.
Yes.
My lord, the petitioner, he was arrested on
27, 2023, my lord. I'm in custody for more than 2 years, my lord. Your lordship, kindly,
Trial is going on.
trial is going on, but it has not progressed substantially, my lord. Right now it is fixed for, I think, copy, my lord. Copy, no?
Punishing copy only.
Well, because
yes,
of the
madam.
non-representation of the accused,
One of the accused,
the
he has not
copy could
engaged
not
any
be
advocate.
furnished. So now it is fixed for copy, and number of direction has been given to the accused person to bring their lawyers or to be represented by some legal person. And because of that, it is
What is
getting.
the accusation?
Beg your lordship.
Yes, what is the accusation?
Your lordship, as far as the annex of page 70, my lord. Annex of 1. Name,
Why the trial court rejected your prayer?
it was at the early stage, my lord.
Now you have not prayed before the trial.
Right now I have not applied for bail there, my lord. After filing of the search.
Charge sheet. You should have applied there first. After filing of the charge sheet.
Subsequently, means a few others accused applied for bail, but that was rejected. I had also applied earlier, my lord. There, that was rejected, my lord. After that, after filing of the that was after filing of the search, my lord. But at that time, cognizance was not taken, my lord. Cognizance was taken subsequently, my lord. Already, 2 of the accused has been granted bail by the coordinate bench of this honorable court, my lord.
Where is that bail order? But after filing of the charge sheet, you should have read before the trial court.
I filed in the application, my lord, but at the time cognizance was not taken because of that. Means, yeah, it was rejected. The bail has been granted only due to the long incarceration of the petitioner, my lord, as because the trial has not progressed sufficiently, my lord. Your lordship will kindly have a look at the order.
Yes. The co-accused have been granted bail.
Yes, may I please your lordship? For the first time, the one bail application was filed earlier in the month of last week of April, and it was heard on 9. A pronouncement was made on 9/5/2025. It was filed by one Arun Pundam and another one is Kiran Mehti. Both the bail application has been rejected on the last occasion. I can give you the.
This one.
Huh?
This
He
one.
said. Last.
First one.
So A to first to be as.
Okay, but later
This
on,
was first application filed by them and it was rejected.
what is your
Now-
name, Arun?
A second,
Yes, sir.
Bo-
No,
How
earlier
many-
the
how
person
many
who has been granted
petitioners?
bail, he is in Arun.
What
The
is
Arun
your
has been
name?
granted bail, but this is Tomba.
How
he is
many-
Tomba, one of another accused
How
person.
many petitioners are there?
Only one petition.
Only one,
In this application.
Here only one. Here only.
Tomba Singh.
And on the second bail application, against which on 8/9/2025, the learned trial court, the honorable the court has given the order on 8/9/2025. Paragraph number 22 may kindly be seen. Paragraph number 22, your lordship. Shall I go through?
Yes,
Consequently, the accused petitioner Hemay Kiran Mitai be released on bail in connection with the above mentioned case on furnishing so and so, and these are the stringent conditions. There, number one, since the trial is transferred to the state of Assam, accused petitioner shall reside at the permanent address in the district of Thombal, Manipur, and shall not enter the district public place where the victim and their families presently reside. The accused petitioner shall mark the attendance once every fortnight. Then third is the accused petitioner shall surrender his passport if any. Fourth is the accused petitioner shall not directly, indirectly contact, influence, so and so. Fifth is the accused petitioner shall appear on each and every date fixed by the trial court. Sixth, the concerned IO of the SIT in connection with this
Okay,
case.
stringent conditions were,
These are the conditions. Thereafter on 23, paragraph number 23, which is the crux. It is made clear that the present order granting bail is passed in the context of the peculiarity of the individual facts and circumstances of the accused petitioner. Herein particularly the prolonged and pre-trial custody and delay in commencement of trial vis-a-vis the role implicated against the accused petitioner in the alleged offense. This order shall not be treated as a precedent or binding for consideration of bail of any other accused whose application shall be decided independently on their own merit. The trial court is directed to take all steps. So this is the crux of the case. So this matter has to be individually considered. And otherwise also the Supreme Court on number of occasions given a verdict that the parity in case of the criminal
how
is-
his case is different from the case of the petitioner who has been.
Yes, he has identified the accused person, victim has identified the accused person, and CD has, IU has brought the CD also.
Victim
And from
has
the CD,
identified
I
the,
have taken out the important papers.
victim has identified the present petitioner.
Yes, sir.
That's a matter of trial.
I'm giving your lordship. This is the statement recorded before the magistrate.
How many witnesses are there?
Altogether 39, I suppose.
CD Bulandis.
Who
I
has
see.
identified?
I'm giving victim. Victim
How
one,
many victims are there?
1, 2, 3. They have identified the accused persons. This is.
Not
on the
accused persons, present petitioner, whether they have identified.
And photo identification I am also giving. This is the 164. These are the material which I have, for the sake of convenience, get the photo state so that your lordship can look into their statement.
Okay.
I'm coming to their statement, your lordship.
Mm.
My name, shall I go through?
No, I'll go through.
Because it is a bit, I mean, the page number 104 may kindly be seen.
Of
That is D4.
of the loose sheets or
No,
of the
this-
bail
just
application.
now, yes, I have given. Just now I have given from the part of the CD, Lucy. D4. D4.
10.
And I have given one photo PIP. Photo PIP. there is.
You flag the relevant.
That is why I separated from all the relevant paper I am giving you. Total paper which I am giving, these are the relevant from the CD.
What is your submission? That
My
he has
submission is
been
a-
identified
it is a-
by
it is a such-
TIP. During TIP, he has been identified by the witness. The witnesses have identified the present petitioner.
Yes, sir.
There is material regarding his involvement.
In the mob, yes.
What they had done, what
So then I
what
will
is-
have to read
what is the accusation?
accusation. I'm
There is
going
no-
to-
No, don't read.
Also, there is no specific accusation against the present petitioner. my lord.
It is there, she has
There is a mob of-
identified, he was present in the mob. So
What
she-
mob did?
You're listening, kindly,
No, you can answer my query. What it did?
There was a mob of around 800 to 1,000 persons. They entered into villages of 50 persons. The entire village was burned down with it.
Okay.
And all the houses were damaged, properties were damaged, my lord. And after that, 5 persons fled to the nearby village, my lord. Then subsequently, those 5 persons are police recovered that 5 persons. While the police were taking them to the police station, 2 of the persons were killed by the mob on the spot, my lord. And 3 persons, ladies, they were taken custody by the mob. They were paraded. There was naked parading of those 3 persons.
It's not
ladies,
only the
my lord.
naked parading, it is given in the charging
And
your
one
lordship,
one-
which will
One
speak
lady
the
was
truth.
Let
raped
him,
by
let
3
him.
persons.
Rape is also there.
Yes, my lord, by a few of the persons, my lord.
It's such a monstrous crime.
Whether,
We
whether
cannot
in,
even imagine it has ever been happened in the universe.
whether someone has identified his involvement in this.
Yes,
My lord,
that is
for
why.
the conspiracy
That is
crime, he is not, there's no allegation.
You
against the
flag
person for the
the
concept of crime, my lord.
third, Mr. Rajshekhar.
why. And
Leonard.
I don't know some judgments. I have number of judgments I brought of the Honorable High Court in the heinous crime like this.
Okay.
It is a, whatever the heinous.
Okay,
crime
no,
is,
I understood gist of your submission. That offense involved is heinous. There are materials against the petitioner.
And my whole submission, a charge sheet may kindly be looked into. And
Okay,
apart from that, 164.
you flag mark the this application under section 483 of BNSS has been filed by the petitioner, namely Ningombam Tomba Singh, who is seeking, who has been detained behind the bars since 27/2023 within bracket, no,
These are the judgment I have furnished your lordship to look into.
but in
However,
the,
our crime is much more higher than this judgment.
okay, I have understood, but you flag mark
Yes.
where the witnesses have implicated him.
These are the
Implicated.
paper purely related to the witnesses and the victim. These are the paper.
No, you
I have-
understood my query.
Yes.
The specific averments of these witnesses where the present petitioner has been implicated by them. You flag mark. ये लिख लो last line. Since 27/2023, within bracket for more than 2 years, in connection with, what is the special case number?
Special case number. The special case number at present is 7/2025.
In connection with special case number 7/2025, corresponding to Nongpom Sekmai Police Station case number
You also can you record the CBI case number RC 12 CBI.
in connection with the CBI case number RC 0562023 S0012 under section code sections from the first page of the second page of the bail application. The gist of accusation in this case is that on what is the date of FIR?
Date of FIR is initially the FIR was lost at Cycle Police Station, that is on 18/5/2023. They
On-
registered the zero FIR
On
as because the incident took place under Cycle
That
under
on-
Nongpuk Chekmai Police
what is
Station.
the date?
So subsequently it was transferred to Nongpuk Chekmai Police Station where the final FIR was registered. That is 110.
When it was filed? 18?
You will also find it in para 3, 18/5/2023, my lord.
18/5/2023. One. Hangboi Waipei had lodged an FIR
28.
before
18/5.
the officer in charge of Cycle Police Station, Inter India, in that on 4/5/2023 at about 3 p.m. some around 900 to 1,000 people, mostly belonging to various Meitei organizations, armed with sophisticated weapons, forcibly entered into the village of the informant and vandalized and burned down all the houses and looted valuable properties. Stop. It is further alleged in the affair that 5 people within bracket 2 males and 3 females of the village who fled to nearby jungle were rescued by police and were taken to the police station. But while they were being taken to police station, a violent mob stopped them on the road and forcibly took them. The 2 male persons were killed by the mob and 3 females were stripped naked in front of mob. And one of the victim was even gang rape. Stop. Learned counsel for the petitioner has submitted that no specific accusation against the present petitioner has been made in the affair. He further submits that the petitioner has been languishing behind the bars for more than last 2 years, and the progress of trial is progressing at a very slow pace. As till date, even the copies of documents submitted by the prosecution side along with the charge sheet have not yet been furnished to the petitioner. He further submits that one of the co-accused, namely Arun Hung Dong Bam,
Also, two of the co-accused has been granted.
2 of the co-accused have already been granted bail by a coordinate court, mainly on the ground of prolonged incarceration. The petitioner, learned counsel for the petitioner, submits that the petitioner is ready to cooperate in the trial, and as he has been languishing behind the bar, which has resulted in violation of his fundamental rights guaranteed to him under Article 21 of the Constitution of India, he may be allowed to go on bail. You are relying on these cases. Learned counsel for the petitioner, in support of his submission, has
I'm furnishing the copies.
cited following the quote the citations from page 3 of the bail application number 2039. ইয়াতে লগত আছে। Mention about the judgments are there in the
Yes, already it is there in the order.
stuff. On the other hand, Ms. M. Kumari, learned standing counsel, learned special public prosecutor CBI, has vehemently opposed the grant of bail to the petitioners on the ground that though the coordinate bench has allowed the 2 of the co-accused on bail, however, while granting bail to them, it has also observed that the bail to the co-accused grant of bail to the co-accused should not be treated as a precedent or or binding for consideration of the bail of other co-accused. She submits that the application for bail of the present petitioner should be considered on its own merits. She also submits that there are sufficient materials against the present petitioner in the case diary, which clearly indicates to his complicity in the offense alleged in the FIR. She further submits that the present petitioner was identified by the witnesses during test identification parade conducted by the investigating officer. She also submits that
Victim 1 and victim 2 has identified.
she also submits that the victim girls, these are girls,
These are
victim girls have also implicated the present petitioner.
that is the case only. Victim 1, victim 2, and victim 3. There are 3 victims
So,
who are brutally gang raped, and their statement will speak the truth.
I'll go through this statement.
Just now I have flag marked and it is there, Your Lordship.
Okay.
This is from the CD, part of the CD. I have segregated for the convenience of Your Lordship.
He has also produced the relevant she has also CD is with you.
Yes, CD is here.
She has also produced the case diary of the of this of the aforesaid case in support of her submission.
Here, 164 statement is recorded in Manipuri that has been translated again in the English. And that is document D4 and D5 from the record I have furnished, Your Lordship.
She has cited following rulings in support of her submissions. Quote the rulings from page 4 of the bail application number 2039/2023. I have considered the submissions made by learned counsel for both sides and have gone through the case diary, which has been produced. Case diary. Stop. Without the book. I'll pass orders after going through these statements in the chamber today itself. Idina lage.
May it please your lordship. My lord, earlier your lordship has granted two of the accused bail. My lord, I have annexed the copy. And this petitioner is, my lord, on the same day she was arrested, my lord. And on the basis of the statement of the other accused, my lord. Lordship, may kindly see page 74. Annex 7 order. On the ground of my lord delay. And the case is still, my lord, two witness only, my lord, examined, and third witness still uncompleted, my lord.
Where page number?
Page number 74, your lordship order, my lord. Even 3 accused, my lord, 2 of them lordship have granted bail.
Yes.
Your lordship, some time may be required, your lordship, let me get instructions in this matter, whether against this judgment which fell from your lordship, whether the department has filed any SLP or.
How much time?
Immediately after vacation, your lordship, 13th October or
Yes.
14th October.
Before, my lord, take my lord.
Your lordship, also the trial court records may be also be called for, just Guwahati, Kamrup Metro. Let me get the instructions.
Before vacation, any date, my lord.
Heard Mr. Giuddin, learned counsel for the petitioner. Also heard Mr. What is the name?
D. Bora,
Deborah,
D.
learned,
Bora, Senior Standing Counsel, DRA.
learned senior standing counsel, DRI. Learned senior standing counsel, DRI submits that though two of the co-accused persons have been granted bail on the ground of prolonged incarceration. However, he prays for some time to seek instructions as to whether any appeal has been preferred against the said order by the department. Considering the submissions made by learned counsel for the learned standing counsel for DRI, senior standing counsel DRI, the prayer is allowed. Let the scanned copy of the trial court records be called for. Let this case be listed after on 24th of October.
Highly augment, your lordship.
Item 7.
May it please your lordship. Once you have challenged for charge sheet, my lord, lordship have a look at page 33 for a once more.
Yes,
My lord, your lordship will see, my lord, the name and address of the complainant, my lord, Najma Begum, my lord. And my lord, in the third column, my lord, there are 9 persons, my lord, against whom charge sheet has been laid, my lord. And in the second column, my lord, I am appearing on behalf of 2, 4, 5, 6, and 7, my lord. Lordship, may kindly note that, my lord. I am appearing on behalf of 2, 4, 5, 6, and 7. my lord.
Mohammed Abdul.
My Abdul Karim, then Jamal Uddin, then my Alam Ahmed, Abdul Subur, and Abdul Sukur, my lord. These 5 persons, my lord. But they were
Abdul
not
Karim,
Abdul number 2, Muhammad Abdul Karim,
2, 4
5, 6, and 7
in the second column,
in the second column, my lord.
not sent up for
Not
trial.
sent up for trial, my lord.
Yes, what happened?
Now, my lord, now your lordship will turn to page 35, my lord. Page 35, my lord, the complainant filed an application, a petition under section 173, subsection 8 of the CRPC, my lord.
Okay,
Now, my lord, after filing this petition, my lord, your lordship will see on the left-hand side, my lord, handwritten, my lord, there is a, my lord, the magistrate has stated, my lord, seen, let the copy of this petition be given to the SP Hojai for necessary action.
page number?
Page number 35, my lord, on the left-hand side, my lord. Annexure 3, my lord. This is the petition, my lord, filed by the complainant, my lord. And on the left-hand side, my lord, the magistrate has stated, my lord, seen, let the copy of this petition be given to the SP Hojai for necessary action. Now, my lord, now your lordship will turn to, my lord, page, my lord, 38, my lord. The order passed by the magistrate, my lord. 38, my lord. This is the order dated, my lord, 11/8/2021, my lord. Learned additional PP and the IO are present. Heard both the sides in respect to the petition number so and so filed by the learned APP. In fact, the petition was filed by the complainant, not by the APP, my lord. It is submitted by the IO of the case that's subsequent to the filing of the charge sheet. Some material facts relating to the case has indeed come up, which necessitated further investigation and filing of additional charge sheet, and accordingly prayed for according a leave to further investigate into the case and submit additional charge sheet. Peruse the case record, considering the matter in entirety. The prayer of the IO is allowed with a direction to complete the investigation and submit report within 1 week from today, my lord.
This is a direction, my lord, to submit additional charge sheet, my lord, within 1 week, my lord. Now, my lord, this order was passed on 11/8, my lord. Although the case was fixed, my lord, on 9/8, my lord. 9/8, my lord, there was a, my lord, report from the SP, my lord. The magistrate had asked the SP to give a report, my lord. That report was filed, my lord, before the court, my lord. That copy, my lord, I could not obtain the certified copy, my lord, as because it was a report by the SP, my lord. In the report, my lord, there was nothing against us, my lord. So thereafter, on 11/8, my lord, the magistrate directed to complete the investigation and submit a report within 1 week from today. And the, my lord, the order was passed on 11/8, my lord. Subsequently, my lord, on 18/8, my lord, next page 39, my lord. Page 39, my lord, additional charge sheet was filed against these 5 persons.
Okay.
And if a lordship
Now,
turns
what is
to-
your grievance?
My lord, my grievance, my lord, I have filed an application before the court below to discharge me, my lord, and that was rejected, my lord. In fact, my lord, charges were framed against the other person, my lord, that those 9 persons under section 302, my lord. And my lord, the cognizance of the case was taken, my lord. And my lord, if your lordship turns to, my lord, page 43, my lord. 43G, my lord. 43G, my lord. 43G, my lord. Well, this is the deposition of PW1 Najma Begum, my lord. Well, trial started against those 9 persons, my lord. And this deposition was given on, my lord, 23/03/22. At the top, your lordship will see, my lord. In a deposition, my lord, she has not stated our name, my lord. If I read, my lord, I am the informant of the case. I know the victim, Samim Alam. He is my son. I also know the
No,
victim.
this deposition was after filing of the additional charge sheet
Yes,
or
my
prior,
Yes, my lord.
prior to filing of the additional.
The additional charge sheet was filed on 18/8, my lord. 18/8.
18/8,
18/8.
which year?
Oh my God, just 18/8/21. 18/8/21.
Okay,
Page 42 will reveal, my lord.
okay.
Charge sheet 18/8/21. And thereafter, my lord, this deposition was taken, my lord. Page 43G, my lord. Where, well, if a lordship, if I read, my lord, our names were not there, my lord. May I read?
No, assuming that names are not there.
Not there. In the 164 also, our names are not there. So therefore, we preferred an application for discharge. We have filed an application, my lord, that is at page 49.
Under what provision?
My lord, now the new BNSS, my lord, there is a provision, my lord. We have to file you can file a petition for discharge, my lord, under section 227 of the IPC. 250 of the BNSS. 250 of the BNSS.
Then what happened?
Now, my lord, in that petition, my lord, page 49, my lord, page 50, paragraph 3, my lord, there is a specific specific statement, my lord, I have made, my lord.
No, but this discharge can be a prayer for 250 can be made only before
60 days.
No, before framing of charges.
Yes. Charges were not framed against us till date, till up to date, my lord. Charges were framed against us, my lord, only on, my lord, 23/7/25, my lord. That your lordship.
Only now.
Now, my lord, page 53, my lord. That is the case, my lord.
So you are impugning
This order, my lord, page 53, my lord. Charges were framed against the other 9 accused, my lord, under 302. Deposition was taken, my lord. Now, charges are framed against us on 23/07/25. That will be clear, my lord, at page 55, my lord. Page 55, my lord.
Now, what is your ground?
My lord, my ground is that, my lord, 164, nothing was against us. The deposition of the deposition of the informant, the complainant before the court, nothing was against us. And moreover, my lord, the superintendent of police, Ojai, my lord, filed a report before
No,
the
on
court.
what basis charge sheet was filed? What, there must be some basis,
No,
or there is no basis at all.
no basis, but only the application filed by the
Then we
informant.
have to peruse that.
My lordship may peruse it, my lord. Because, my lord, if your lordship turns to page 55,
Oh,
third
okay.
third
Let
paragraph,
us call for the scanned copy of the case diary.
and more particularly, my lord, that we had applied before the court below, the report of the superintendent of police, my lord, dated 9th,
That will be available.
that will be available. That will be very much
Heard
required.
Mr. N. J. Datta, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioners, namely Abdul Karim, number 2, Abdus Sukur, number 3, Abdus Subur, number 4, Alam Ahmad alias Khurshid Alam, number 4, Jamaluddin Ahmed, Jamaluddin, impugning the order dated
23/07/25,
23/07/2025,
passed in sessions
passed in sessions
T-1,
T-1 case
case number 21 within bracket H of 2021.
by which charges were framed against the present petitioner under section
302, my lord.
only 302.
302,
147, 302 and 323.
Under section 147,
148, 149, 325, 302/34.
148, 149, 302, 320, 325/34 of the Indian Penal Code. Learned counsel for the petitioner has submitted that in the first charge sheet laid in this case, the petitioners were not sent up for trial as no evidence was found against them. However, later on an application filed by the informant, the court allowed further investigation to be made. And after completion of the further investigation, an additional charge sheet was filed. Learned counsel for the petitioner has submitted that in the additional charge sheet also, there are no materials implicating the petitioners are there. And even the informant who has deposed as PW1 in the case prior to framing of charges against the present petitioner had not implicated them. Stop. To appreciate the submissions made by learned, to appreciate the contentions raised by learned counsel for the petitioner, the scanned copy of the trial court record as well as scanned copy of the connected case diary would be required. Hence, call for the same. Please the registry to take steps for requisitioning the scanned copy. When is the next date?
Next date is 13/11/25.
Before that date. Let this case be listed on 24/10/2020.
I'm obliged.
Please, your lordship. My lord, NBW is issued against me, lordship, for non-appearance on one day, lordship, on the first day itself.
Why?
Lordship, I could not appear because I am a driver, lordship. I have to earn livelihood. I went somewhere instructed.
You received the summons?
Lordship, I was appearing, Lordship. I was appearing only one day, Lordship. I instructed my counsel.
When you defaulted? When you defaulted?
Lordship, page 17, 11/6/25, Lordship. The past date is
When is the next date fix?
next date, Lordship, 25/9, Lordship.
Tomorrow,
Lordship.
appear tomorrow. Let him appear tomorrow.
Well,
Heard Mr. M.I. M.I. Hussain, learned counsel for the petition. Heard Mr. M.I. Hussain, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 528 of BNSS, read with article 227 of the Constitution of India, has been filed by the petitioner on being aggrieved by order dated 11/6/2025 and subsequent orders passed by learned additional Chief Judicial Magistrate Bongaigaon in PRC case number 175/2025, whereby non-bailable warrant of arrest were issued against the present petitioner. Learned counsel for the petitioner has submitted that the petitioner is facing a trial under section 407 of the IPC before the Court of Learned Additional CJM in PRC case number 175/2020. Stop. He submits that he was regularly appearing before the trial court. However, on 11/6/2025, he defaulted. Why?
Chief, I am a driver. I was out of station.
As he was out of station on that day. The petitioner submits that the next date of this case is fixed tomorrow. That is on 25/9/2025, and he is ready and willing to appear before the trial court. However, as a non-bailable warrant of arrest has already been issued against him, he is praying for some protection. So, I have considered the submissions made by learned counsel for both sides and have gone through the materials in the case diary. Stop. Considering the fact that the petitioner is ready to appear before the trial court on the next date fixed and cooperate in the trial, this criminal petition is disposed of with a direction to him to appear before the Court of Learned Additional Chief Judicial Magistrate Bongaigaon in PRC case number 175/2020 tomorrow, that is on 25/9/2025, to facilitate his appearance before the said court. The non-bailable warrant of arrest issued against him by the trial court shall remain suspended till tomorrow. On his appearance before the trial court, the petitioner may pray for any appropriate relief to which he is legally entitled to before the said court.
I think
May I please, Your Lordship? Lordship, for the time being, Lordship, the senior counsel, Mr. K.N. Sudhir is there, Lordship, and he is left on court number 10, Lordship.
What is to be done?
As your Lordship pleases. But it is at the stage of motion, we may be permitted to file reply. So otherwise also it will go for filing of the parawise reply.
Lordship, let him come, Lordship. I have a very good case and let him come, Lordship.
No, he may come. I am not. Okay, we'll take it up after some time.
I am careful, Lordship.
Item 10,
Map please, Lordship. This is Lordship, period, wait, Lordship. And child marriage prohibition, Lordship, and the husband and wife, they are living together very peacefully, Lordship. And one child is their Lordship, and I am very clearly mentioned. And FIR lodged by the police, Lordship. Not by the Lordship, and even then, Lordship, there is no dispute at all between the husband and wife victim, Lordship. But police lodged this FIR, Lordship. In this case, Lordship,
You are for,
I am for respondent number 3, victim, Lordship. Wife, Lordship.
you are the wife.
Yes, Lordship. Actually, Lordship, this types of FIR for the only intention is harassing someone, Lordship. For the filing of this FIR, Lordship.
Yes, Mr.
Lordship, victim
Parashar.
itself also
Okay,
suffer.
Mr. Parashar.
My lord, now 3 years old child is there. But
It is pending investigation. Heard Mr. F. Hawk, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor, as well as Mr. What is your name? A. Alim Sheikh, appearing for respondent number 3/victim. This application under section 482 of BNSS has been filed by the petitioner, namely Ataur Hussain, who is apprehending his arrest in connection with Dhubri PS case number 340/2025 under section 9/11 of the Child Marriage Prohibition Act 2006, read with section 6/17 of the POXO Act 2012, as well as section 75 of the Juvenile Justice Care and Protection of the Children Act. The gist of accusation in this case is that on, where is the affair?
Case number, Lordship, 17, Lordship,
On
17.
On 5th August 2025, one J. Shyam, SI of Police had lodged an FIR before the officer in charge of Dhubri Police Station, inter alia alleging that on the basis of a complaint lodged by one Noor Hussain and some others to the senior superintendent of police, Dhubri, regarding performance of a child marriage secretly by one Cosmot Ali, who is the father of the present petitioner. A search was made, a search operation was conducted, and it was found that the victim girl, along with her 3 years old child, was found in the said house. Stop. Learned counsel. What is the age of the victim? She
Now,
was
Lordship, more than 21 years, Lordship. 3/31/2005.
And what is your submission?
Well, Lordship, certificate is, Lordship, I am not concerned, but as per the Lordship instruction, she was attained the age of majority of marriage, Lordship, as per Sharia Act, Lordship.
No, Sharia Act does not
Lordship, but
provides
as
for
the time of marriage, Lordship, and the marriage was took place, and she
whether
was
she was 18 years.
Lordship.
Stop. 50 लिख ले last line. Stop. Learned counsel for the petitioner has submitted that this FIR has been lodged only with an intention to harass the petitioner and the victim who is the wife of the present petitioner, and he further submits that victim had attained the age of majority at the time of her marriage, and she is now mother of one minor girl who is aged about
3 years.
3 years. He further submits that the petitioner is ready to cooperate in the investigation, and as victim is his own wife and they are staying together, there may not be any requirement of a custodial interrogation. Stop. On the other hand, an additional public prosecutor submits that considering the date of birth of the victim mentioned in the FIR,
Child date of birth is 26/4/22. So at the age of 17 years, 3 months, she become mother of the.
it appears that the marriage of the victim was conducted when she was 16 years of age. Further, he submits that from the date of birth of her child, it also appears that she gave birth to her child when she was only 17 years of age. Learned counsel for the respondent number 3, who is the victim in this case, has submitted that the petitioner is the husband of the respondent number 3, and they have a child of 3 years old, aged about 3 years out of the said marriage. She also submits that he also submits that the victim does not have any objection if the petitioner is granted granted anticipatory bail by this court. So I have considered the submissions made by learned counsel for both sides. When the marriage was performed,
In the year of 2021, Lordship, until December.
it appears from the perusal of the affair that the marriage of the present petitioner with victim was performed in the year 2021, whereas the affair has been filed after about more than 4 years in the year 2025. Further, considering the fact that the victim and the petitioners are living together as husband and wife and have a 3-year-old child out of the said wedlock, this court is of considered opinion that if the petitioner cooperates in the investigation, his custodial interrogation may not be necessary for fair completion of the investigation of the case. In view of above, this anticipatory bail application is disposed of with a direction to the petitioner, above named petitioner, to appear before the investigating officer of Dhubri PS case number 340/2025 within a period of 7 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, comma, in the event of his arrest in connection with the aforesaid case, he shall be allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority, with following conditions, number 1 and 2. Abhishek or Pralambha conditions.
Deeply obliged, Lordship.
This
Deeply obliged.
anticipated bail application is accordingly disposed of.
Deeply obliged.
Item 11.
My pleasure, Lordship. This revision, I have preferred against the judgment of the both CDM and the appellate court. The original court sentenced to undergo imprisonment for 3 months and to pay a compensation 35 lakhs, in default simple imprisonment for 1 month.
In NI case,
Yes, NI case. The learned appellate court, that imprisonment part is modified, and now only the past order that 35 lakhs pay to the
imprisonment part, how it has been modified? No,
imprisonment part is modified in
Removed.
appellate court. Now
Removed.
only the compensation is 35 lakhs, and in default another 1 month.
okay.
I am submitting the honorable court may issue the notice that this negotiable instrument case that any stage it may be solved also, because some point I have raised out that complaint
Heard.
need-
Mr. Ainuddin, learned counsel for the petitioner. Also heard. State is not a party. Also heard Mr.
also.
K.K. Parashar, learned counsel for respondent number 1. This application under section 438/442 of BNS has been filed by the petitioner, namely Abu Muhammad Ahmed, impugning the judgment and order dated 3/6/2025, passed by learned Session Judge Bajali in Criminal Appeal number 14/2023, whereby it partly allowed the appeal preferred by the present petitioner and had modified the sentence imposed on the petitioner by the trial court in NI case number 11/2022, to the extent that the petitioner was directed only to pay compensation of 35 lakhs to the respondent, and in default to undergo simple imprisonment for 1 month. Issue notice to the respondent number 2 by registered post with AD as well as by usual mode within 1 day, within 7 days from the date of this order, returnable after 4 months, returnable after 4 weeks, list accordingly.
Judgment maybe stay.
No, let the
Maybe
Any-
he will come and
whether warrant has been issued against you. No.
till now, but
So no interim when there is no urgency.
if I cannot show the stay order, the warrant will be issued.
When warrant will be issued, you come again to this court.
Some another problem, maybe stay because
No. Stay is not granted so easily. Interim stay, you have to make out a case. merely by filing a revision petition,
I have taken some ground also, my lord, because
the prayer for interim
I'm praying for interim, my lord.
date, fixed date दिया कहता.
Till return date, my lord, then he will come.
No, let this case be listed again on 27th October. The prayer for interim relief would be considered only after due service of notice on the respondent number 2.
May it please the Lord. My lord, criminal revision petition, my lord. CJM court, my lord, I was convicted under section 294, 325, 506 IPC, my lord. I challenged the same by way of an appeal, my lord. And my lord, conviction, my lord, under section 325, my lord. Earlier, other two sections, 294, 506 IPC, my lord. I was, my lord, not convicted, my lord. Prosecution side failed to prove the same, my lord. Only 325, my lord. Now, my lord,
What was the sentence?
sentence, my lord, 6 months imprisonment and fine, my lord.
What is your ground?
Ground, my lord, 325, my lord. At the very inception, my lord, of this case, there was, my lord, an altercation took place between the present petitioner and 5 numbers of other person. There was a cross case filed, my lord. This particular case, I was convicted, my lord. And the cross case, the other accused persons were convicted, my lord, including the informant of this present case. It was a fight of 1:5, my lord. 5 persons from the other side, and I stand for 1 person, my lord. My case is, my lord, 325.
No. You have to submit where is the error of the appellate court?
Yes, my lord. That is what I'm coming, my lord. My lordship, may kindly come to page number 106, my lord. That is before that, my lord, page 23 for a moment, my lord. That is the initial FIR at the very inception, my lord.
No, you make your submissions regarding the grounds.
My lordship. Page 106 is the judgment, my lord.
On what grounds you are challenging the?
My ground, my lord, 325. There was, my lord, injury. But, my lord, the trial court as well as the appellate court failed to take into consideration that to constitute an offense under section 325, not only injury is important, my lord. The first part, my lord, that is the intention and knowledge to cause such an injury has to be present, my lord. Simply sustaining an injury will not, my lord, constitute an offense under section 325. So to constitute, my lord, there has to be intention.
Heard Mr. M.K. Das, learned counsel for the petitioner. Also heard Mr. K.K. Parashar. Yes, Mr. Parashar, anything? K.K. Parashar. Learned additional public prosecutor. This application under section 401/397 of why 401/397?
My lord, calling of records.
Why not under 438 and 442 BNS?
Yes, my lord. 442 and 438, my lord. Subsequently, I have written, my lord. The same.
You should stop using
My lord.
the CRPC provision. Under section 442/438, instead of 401, this application under section 442/438 of BNSS has been filed by the petitioner, namely
Sonanda
Boro alias Sunanda Baro, impugning the judgment and order dated 17/7/2025 passed in criminal appeal number 16/2025 by the Court of Learned Sessions Judge Udalguri, whereby the whereby the judgment passed on 24/3/2025 in GR case number 528/2022, whereby the present petitioner was convicted under section only under 325.
323 is also there, my lord. 325 against one and 323 against other, my lord.
Against you?
Page 171, my lord.
No, against you?
I am the, my lord, against me, my lord, there is a separate case, my lord, cross case. This case
No.
is
Under what provision you were convicted?
325/323 IPC, my lord. Page
Both,
171.
both.
Both, my lord. The 5 numbers of, my lord, other persons involved, my lord.
Where is the order?
Page 171, my lord. Para 10, my lord.
How you can be convicted under both?
My lord, there were 5 numbers of, my lord, persons who indulged in altercation with me, my lord. And the allegation against me that I caused grievous injury to one and simple
What
injury
the
to
appellate
two.
court did?
Appellate court, my lord, convicted me, my lord. 325, 323, my lord.
Both.
My lordship. Initially, it was not there, my lord. But subsequently, at the time of conviction, 323 was added, my lord. So I never got a chance to, my lord, defend myself with regard to 323.
Under section 323/325 of the Indian Penal Code, and was sentenced to undergo simple imprisonment for 6 months and to pay a fine of rupees 8,000 and to suffer, and in default of payment of fine, to suffer further imprisonment for 1 month under section 325 of the IPC. The petitioner was also sentenced to undergo simple imprisonment for 1 month and to pay a fine of rupees 1,000 and default of payment of fine to undergo simple imprisonment for 10 days. So, learned counsel for the petitioner has submitted that both the trial court as well as appellate court erred in convicting and upholding the conviction respectively of the petitioner under section 323/325 as the ingredients constituting the aforesaid offense were absent in the case of the petitioner. The learned counsel for the petitioner submits that the petitioner is hopeful that he may get a favorable result in this revision petition. Stop. He further submits that you are praying for interim. You are on bail.
My lord. After conviction, my lord, is for the first time it has come, my lord. So
You are-
right now I'm not on bail.
The petitioner further, learned counsel for the petitioner further submits that as the sentence imposed on the petitioner is for a short-term period of 6 months only, unless the execution of sentence imposed on the petitioner is stayed during the pendency of the present criminal revision petition, the same may become infructuous. Stop. Issue notice to the respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 by registered post with AD as well as by usual mode. within 7 days from the date of this order, returnable after 4 weeks. Stop. In the meanwhile, considering the submissions made by learned counsel for the petitioner, as discussed in the foregoing paragraph, comma, the sentence imposed on the petitioner, the execution of sentence imposed on the petitioner by the impugned judgment shall remain suspended till the pendency of this criminal revision petition. The petitioner is also allowed to go on bail of rupees 30,000 with one surety of like amount during the pendency of the criminal revision petition number 383/2025, subject to the satisfaction of learned. Which is the trial court?
Trial court, my lord, page 106, my lord, order dated 24/3/2025.
Which is the trial court?
Trial court, Udalguri, my lord.
Udalguri is the place I am asking.
My lord, district and session judge, Udalguri.
It is the appellate court.
Appellate court, my lord.
Which is the trial court?
Judicial magistrate, first class, Udalguri, my lord.
To the satisfaction of learned judicial magistrate, first class Udalguri, in the GR case number 528/2022. Subject to this. Subject to the satisfaction, subject to the condition that in the event of dismissal of this criminal revision petition, the petitioner shall surrender before the said court to serve out the remaining part of the sentence imposed on him by the impugned judgment, list accordingly.
Only, my lord, stay of realization of fine, my lord. Suspension is there, my lord. Stay of realization of fine is also one of the prayer, my lord.
The sentence is stayed.
My lord.
Sentence include both fine and imprisonment.
Deeply obliged.
May I please your lordship? Lordship, this is a criminal revision petition against an order passed by the family court. Impugned orders on page 424, your lordship.
Page number?
424, your lordship. It's voluminous, your lordship, because of the assets and liabilities submitted by both by the parties. From the last, your lordship, 4-5 pages, you'll get 424, your lordship.
What has been directed?
Your lordship, if I may read,
No,
basically.
don't read, tell me.
Lordship, thing is, this case was, this is for the 125 maintenance was filed before the honorable court and 29/4/2024, your lordship. And the order was passed in, interim maintenance order was passed on 16/6/2025 from the date of order and not from date of order, not from the date of application as required, which is settled precedent of law.
Your wife?
Yes, I'm for the wife, your lordship.
Okay.
And should have been from the date of application, your lordship. And it has actually been given from the date of order. And
We'll issue notice. Miss, what is her name?
Nikita N. Borwa.
Dr. N. Borwa, learned counsel for the petitioner. This application under section 442/438 of BNSS 2023, said with section 19 within bracket 4 of the Family Courts Act 1984, impugning the has been filed by the petitioner, namely Srimati Monmi Sonapati, impugning the order dated 16/6/2025, passed by learned Principal Judge Family Court number 3 in FC within bracket criminal case number 227/2025, where whereby the 2024, whereby the respondent was directed to pay an interim a maintenance amount of rupees 30,000 to the petitioners and 30,000 to you and 15,000 to your son.
No, cumulatively,
30,000 to petitioner,
collectively.
including 15,000 rupees, 15,000, no, out of which rupees 15,000 was allowed, was directed to be paid to the younger son of the petitioner.
Who is staying with her? Your Lordship?
The grievance of the petitioner is that by passing the impugn order, the learned principal judge family court had directed the opposite party, directed the respondent to pay the maintenance allowance from the date of the passing of the order, whereas it ought to have from the date of the filing of the maintenance application for maintenance. Stop. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. After 4 weeks.
There is a challenge to a charge sheet, my lord. I think when the TCR has come, my lord, what should I fix it for admission, my lord? Because the next date is on 28/11/25.
Okay. Heard, Mr. N.J. Datta, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This is item number
Item number 14, my lord.
14. It appears that in this case, the scanned copy of the trial court records have been received. However, this matter appears to have been wrongly listed under motion column. Let this matter be listed in admission column after puja vacation on a date to be fixed by registry.
Please, but because in the code below, my it is fixed on 28th.
On 30 September.
30 October.
30 October.
30
October.
15, my lord, here it's a challenge to an FIR, my lord. Notice at this stage.
15. Heard Mr. N.J. Datta, learned counsel for the petitioner. Also heard Mr. K.K. Parasha. Charge sheeted case.
No, but only the FIR and
So
challenge.
let the case diary be called for. Let this matter be listed on 24th October.
My lord, respondent number 2 registered post.
Let also, it is a POXO matter.
No POXO, my lord. Challenging the FIR, my lord, that's why.
Let also the notice be issued to respondent number 2 by registered post with AD as well as by usual mode. The petitioner shall take steps for issuance of notice upon respondent within 7 days, returnable after 4 weeks.
I'm applied.
Item 16. May it please, your lordship. Lordship, this petition paying for Rima of the motorcycle. Hello, sir, my friend is supposed to.
Lordship, we have taken the instruction, Lordship, charge sheet has been late. So they filed a petition during the investigation of the case. Now, Lordship, the instruction we have received, this charge sheet has already been late, Lordship.
You pray before the trial court.
Trial court, or I may approach to the IO, my lord. Which relevant documents, if IO is.
No, when charge sheet has been laid, IO will not pass orders.
On
Ah.
appearance, my lord, learned court to.
Yes, heard Mr. M.R. Khandekar, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Learned additional public prosecutor has submitted that though the case diary was called for, however, in the meanwhile, charge sheet has been laid. You have the numbers
Yes, lordship.
bearing charge sheet number.
Receipt number 102/25, dated 29/6/25.
In view of this fact of that charge sheet has been submitted, the petitioner may approach before the trial court and may pray for Jumma of the seized motorcycle by filing an appropriate application before the said court, if so advised.
On being filing.
Item 17.
Learned court below will pass necessary.
It always passes necessary order.
I am.
May it please your lordship. In the matter, the charges had already been filed without NPW issues without we have been shown absconded. We are ready to appear before the court without and face the trial without.
Why you have not appeared?
Regarding the charges filed on 23, we are not aware of this as investigating authority has shown us we have been absconded, my lord. Since we have come to know, my lord, we have stated in paragraph 9 of our application, my lord, we are not actually not aware. On last occasion, my lord, I took time, my lord, regarding some instruction, my lord, instruction regarding whether they have received any notice. Even I'm being told by my friend, my lord, even no notice has been received by the absconded.
When is the next date fixed?
My lord, on 11 November 25.
Mr.
PK.
P.K. Deka, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 528 of BNS has been filed by the petitioners, namely Mostaq-Uddin Laskar, Chinoy Mia, alias Sinoy Mia, Saddam Hussain, alias Syed Hussain, Moizul Hussain, who are aggrieved by order dated 6/8/2025, passed by the Court of London, Additional Chief Judicial Magistrate Hailakandi in PRC case number 284/2023, whereby non-bailable warrant of arrest were issued against the present petitioner. Learned counsel for the petitioner has submitted that in charge sheet, you are shown as absconder.
Yes, my lord.
Submitted that in the aforesaid case, charge sheet has been laid against the above named petitioners under section 147/148/141/324/325 of the Indian Penal Code, showing their names in the column of absconding accused persons. Learned counsel for the petitioner has submitted that the petitioners have never received any notice either from police or from the trial court.
It's informed me, my lord.
As instructed. Trial court. Stop. Learned counsel for the petitioner further submits that next date of the case,
11 November.
next date of PRC case number 28/2023, 284/2023 has been fixed on 11 November, and the petitioners are ready to appear
Yes.
before the trial court and are ready to cooperate in the trial. Stop. I have considered the submissions made by learned counsel for both sides. Since the petitioners are ready and willing to appear as well as cooperate in the trial. This criminal petition is disposed of with a direction to all the petitioners, all the above named petitioners to appear before the Court of Learned Additional Chief Judicial Magistrate Hailakandi in PRC case number 284/2023 on the next date fixed that is 11th November 2025. Stop. And cooperate in the trial. Stop. To facilitate such appearance by the above named petitioners, the operation of non-bailable warrant of arrest issued against the above named petitioner shall remain stayed till 11/11/2025. Stop. On their appearance before the trial court, the petitioners may seek appropriate relief to which they are legally entitled, if so advises.
Item 18.
Please, my lord, here is the case we have filed for the quashing of the entire proceeding, my lord, because my lord, both victim and the boy, they are the joint petitioners. Yeah, my lord, what happened?
Joint petitioner?
Yes, my lord. Yeah, in the nutshell is that, my lord, first affair was lost on
What is the
July
stage?
8th. Thereafter, my lord.
What is the stage of it? Is pending invest.
Appearance, my lord. Also, I am supplying a copy.
You are on bail
Yes, I am on interim bail.
granted by
This on your lordship only, my lord. I have an next man. Then, my lord, what happened? We have decided to marry my lord, and after tomorrow, my lord. And she has withdrawn also, my lord. And I have annexed, my lord, marriage invitation also, my lord, at page 24. Initially, my lord, she lodged an application before the police station, my lord, for withdrawal of the case, my lord. Even though, my lord, the case was forwarded to the jurisdictional court at Dhamaji, showing the cause of action. Thereafter, my
whether
lord,
the victim is minor.
that time it was a matter.
When?
Even at the time of affair, she was little bit, my lord, 2 months short of 18. Now they are major, my lord. They have decided to marry, my lord, each other. And she is residing at this moment, my lord, at my home also.
Yes, Mr.
For which, my lord, your lordship was pleased to grant me bail.
Mr. Sharma, we'll call for the
Records.
records.
On bail, lordship. So,
Yes.
Further proceeding, my lord, is the on.
No, you are
14, my lord.
on
That has to be
14
stayed, my
bail.
lord. And I am marrying, my lord, after tomorrow.
14, which 14?
14/10. 10, my lord, next month. Till then, my lord, maybe stayed and call
We
for
will
the-
fix it on 13/10.
It's a holiday, maybe. Holiday, maybe. Puja vacation. Lordship call for the record and one chance be given, my lord, till then.
for appearance, lordship. They can always take an adjournment, lordship. On that day,
I have taken a last occasion, my lord. I have a next last page at
Heard Mr. J.I. Borbuya, Learned Counsel. How you will overcome POXO in
My
this
lord,
case?
otherwise, my lord, so is that, my lord, even though, my lord, she is my wife from day after tomorrow.
No, she is your
That,
wife.
my lord, she will depose before the court and mistake of fact, my lord, for which she has already written letter to the concerned OC.
Okay.
That was not been considered. I have annexed, my lord, lordship will see at page 40.
Heard Mr. J.I. Borbuya, Learned Counsel for the petitioner. Also heard Mr. B. Sharma, Learned Additional Public Prosecutor. This application under section 528 of BNSS has been filed by the petitioners, namely Bhumusa Basumatari, alias Bhumusa Basumatari, and Ruyum Taid, jointly praying for quashing of the proceedings of special POXO case number 31/2025, pending before the Court of London Which court it is pending?
Special Judge
Special Judge
Damaji.
Damaji. Stop. Learned counsel for the petitioners has submitted that the petitioner number 1 is the accused in the aforesaid case, whereas the petitioner number 2 is the victim of in the aforesaid case. He further submits that both the petitioners are going to be married on
26, my lord, special we have raised, we have already applied. Page 24 and 25 be seen, my lord.
when are you going to be married?
26, my lord, of this month.
On 26,
Kalini, day after tomorrow.
26 September, that is day after tomorrow. Learned counsel for the petitioner submits that there is unlikelihood that the pending trial would result in a conviction as the victim as there has been a compromise between the parties and both the victim and the accused, who are the joint petitioners of this criminal petition, are going to be married. Stop. Issue. Stop. Let the scan copy of the records of POXO case number 31/2025 along with the connected case diary be called for from the trial court. Registry to issue requisition and to take steps for requisitioning the scan copies. Stop. In the meanwhile, considering the submissions made by learned counsel for the petitioners, the further proceeding of special POXO case number 31/2025 shall remain stayed till the next date fixed. Release this matter again on 6th of November.
Similar petition, my lord, for quashing of FIR, my lord. Can we see the FIR, my lord? He suspected the petitioner to be a foreign nation, my lord. And he, in violation of the Supreme Court mandate, my lord, he took the petitioner from his house and he made a report, my lord. Inquiry report can we see at page 14, my lord. Regarding the nationality of the petitioner, he submitted some documents, my lord. But, my lord, the inquiry officer, my lord, can you see page 14? Here the Supreme Court clear mandate in the case of Rahmat Ali, my lord. Can we see the paragraph 34 Supreme Court mandate?
What it says. No, but here you are praying for quashing of a criminal proceeding.
My lord, inquiry officer should refer the matter to the SP, my lord. If any information regarding the foreigners, my lord. He may inquire the matter, my lord, but he forward it to the SP, my lord. SP, my lord, if think fit, my lord, he may submit before the foreigners tribunal for inquiry and proceed with the matter, my lord. And petitioner should have the opportunity of section 9 of the Foreigners Act, my lord, to prove his nationality. But in this matter, my lord, he randomly, my lord, pick up and he made an inquiry report and submitted before the police OC and of the concerned PS, my lord, and OC registered a case, my lord.
Then what happened?
Then, my lord, he, after 10 days or 13 days, he enlarged bail, my lord, by the
You're on,
district judge.
you're on bail.
Yes, my lord, now on bail.
Okay.
Now bail, and my lord, he appears in every month according to the condition of the bail, my lord.
We'll call for the case diary. It is pending investigation.
Foreigners matter, my lord.
We'll consider your submission. Heard Mr. A.H. A.J. Atia, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner Abdul Sahid, praying for quashing of the inquiry report, which is treated as an FIR in Murajhar PS case number 121/2025 under section 61 within bracket 2/319 within bracket 2/336 within bracket 3/340 within bracket 2 of BNS, read with section 4 of the Foreigners Act. Section 14 of the Foreigners Act. Let the case diary be called for.
In the meantime, my lord.
You will appear for both the.
By name, Lordship, he has been read, Lordship.
He's the
Who is number 2?
number 2 is the SI, Sub Inspector of Police Border.
PP may appear because this is a criminal petition. As learned additional public prosecutor has appeared for the respondent, no formal notice need to be issued to the respondent. Release this matter on 27th October.
November, my lord, second week of, because
Second week of November.
my lord, interim protection, my lord, may I suspend my.
Just a minute. 14th of November. What interim protection? What interim? You are already under protection.
My lord, every month I have to go and
That
when there, my lord, he misbehaved me. He said
that you can complain to the court which granted you interim protection. Let the investigation go on. We will consider your
stay for the matter.
stay of the investigation. No.
Because
It will not harm you in any way.
not authorized for the investigation, my lord, under.
That we will
Foreigners Act.
examine. That we will examine. That is your contention in this case.
Yes.
That we will examine. But this is not a case for stay of investigation. 14 November.
Item 20.
May I please, Alaj? Also, this is a matter regarding to
Filing of second FIR. My lord, may come up to page 26. This is the first FIR, my lord. In 2023, my lord, one FIR was filed. My lord may come up. And my lord will reset one thing. The IO in this case is the Ajarkari is the second FIR. My lord must see page 28.
Where is the FIR?
First FIR, my lord, is at page 26, my lord.
No, where is the FIR?
FIR is at page 21.
20?
20. First FIR.
Yes.
My lord, what had happened? I was a police officer, my lord. We wanted to nab the culprits. They were into smuggling, my lord. So we got into their house, but did not find anything. Eventually, what happened, my lord? They filed a FIR against them, alleging that we want to extort money along with our other officials. So what happened? They filed an FIR before the CM. CM passed it on to DGP, and DGP then registered a case. We were arrested. Eventually, we were granted bail. Now, what happened after that, my lord? In 2024, in order to again arrest us, they again filed one more FIR. That FIR is at page number.
What was the date of alleged offense in the first FIR? 16/7/2023.
Yes, my lord. FIR was at 31/8/2023.
31/8/2023.
FIR was registered, my lord. Page number 26, my lord, is the registration of that FIR.
And where is the second FIR?
Second FIR is, my lord, at page 26, my lord. Second FIR 46, my lord. 2/4/2024, my lord. And that was registered on 21/6/20.
What is the date of alleged offense?
Same, my lord. My lord, may read out, I'll read out, my lord. FIR based on outcome of investigation of CID PS case number 14 of so-and-so under section so-and-so, so-and-so, so-and-so. With reference to the above, I have the honor to submit that on 31/8/23, the complaint petitioner addressed to the Honorable Chief Minister, Assam, and signed by the Ribul Islam. This is the person, resident of so-and-so, so-and-so, district Bajali, Assam, praying for taking necessary action against Sat Boragohai, the SP Bajali, Srimati Gayatri Sonwal, Pushkal Gogoi, Bajali, Anup Jyoti Patri, and then the officer in charge. My lord, may come up to para 2. During the investigation of the case, it was found that the accused police officer, Siddharth Buragai, joined as Superintendent of Police Bajali on so-and-so. He was discharging his duties and responsible as Superintendent of Police of Bajali Executive Force DEF on the date of occurrence. Incident that is 15/7/23. During investigation, one
15/7.
Huh?
15/7/2020.
Yes, my lord.
In the earlier FIR, it was 16/7.
Same, my lord.
How 15 and 16 can be seen?
I don't know how they have written, my lord, because it was running out of the same incident. Because, my lord, we'll see in para 2 during the investigation of the case.
Yes.
That is absolutely same, my lord. During investigation, one trolley bag was, which was concealed secretly by Siddharth Buragohai, the SP of Bajar, recovered and seized on so-and-so. 5/9/23. The seized bag belonged to SP Bajali.
What has happened to first FIR?
Charge sheet has been filed, my lord.
Charge sheet has been filed.
Copy is not yet received by us. So now, my lord, very well knows TT Anthony case and was 173/8, my lord. They're supposed to file a subsequent charge sheet. So that is my case.
In the second FIR, what accusation is there?
Nothing, sir. Prevention of Corruption Act they have brought in. Nothing more than that. They could have brought it in the first FIR as well.
And in the first FIR?
First FIR is, my lord, they say it is 120B, 341, 342, 448. Whatever section they could put, they have put. I'm a police officer. I need to go and charge somebody. And in fact, my officers had gone, did not find. That is a separate aspect.
First FIR was under what charge sheet was laid under what provision?
Page 46, my lord. No, second,
First affair.
first of
Charge sheet was laid under what provisions?
all. 46, my lord, in the first line only it is written, my lord. Based on the outcome of the investigation of CID under section 120B, 341, 342, 448. And this trolley bag was seized on the first FIR, my lord. And this was not in my house, my lord. That is one part of the matter. But our only grievance is that how can they come up with a second FIR?
Lordship kindly comes to the second FIR. At page 47, Lordship. There is a separate issue. Lordship. Here,
Right.
Lordship, the second FIR, page 47.
Yes.
47, Lordship, down below, Lordship will come to point number 3, Lordship, paragraph 3. During investigation, the accused Siddharth Borogohain, the then SP Bozali was questioned on the source of such a huge amount of money, except the source money recovered from inside the trolley bag. But he could not provide any satisfactory or suitable answer about the source of money. The recovery of huge amount of unaccounted case has raised strong suspicion that the accused police officer so-and-so, the then SP, has accumulated dishonestly and illegally the said disproportionate assets, properties other than all his known source of income. So that's a different issue.
Yes. What TT Anthony says.
Did you understand, my lord, may come up? Judgment of copy.
So these section registers are also different.
Yes.
That is separate because they could have easily inserted those sections. Purposely, after 1 year, they come up and file one FIR. Just they want to harass us and arrest us. Nothing more than that.
Which?
Para 20, my lord, may come up directly.
Yes.
From the above discussions, it follows that under the scheme of the provisions of section 154, 55, 156, 57, 62, 69, 170, 173, only the earliest or the first information in regard to commission of an cognizable offence satisfy the requirement of 154. Thus, there cannot be a second affair. And consequently, there can be no fresh investigation receipt of the subsequent information and receipt of the same cognizable offence.
Yes. But this was not known.
It was known, money was recovered, absolutely. That is there. It was known. It was second affair, my lord. It is absolutely a second affair.
Yeah, also the disappropriation and
It was recovered on file 923, my lord, during the course of investigation of the first case. It was absolutely within their knowledge, my lord. Only just to come up with the second affair and arrest me, this act has been done. My lord may come up to page para 27 of TT Anthony judgment also. Para 27. My lord may read. A just balance between the fundamental right of the citizen under Article 19 and 21 of the Constitution and the expensive power of the police to investigate a cognizance has to be struck by the court. There cannot be any controversy to subsection 8 of 173, which I indicated. Your Honor very well knows about that. Empowering the police to make further investigation, obtain further evidence, and forward a further report or reports to the magistrate. In Narang case, it was however observed that it would be appropriate to investigation under the permissible of the court. However, the sweeping power of investigation does not warrant subject to citizen to a fresh investigation of police in respect of the same incident, giving rise to one or more cognizant offence consequent upon filing of the successive affair.
What was the incident in the first case?
First
You
case-
entered into somebody's house.
Yes, my
without-
police persons entered because he was
to extort money.
No, my lord.
That was the accusation.
That was the acquisition. my lord.
Yes.
But
That
my-
was the accusation which was investigated into.
my lord,
yes.
During investigation,
when
there was some indication that
No,
you also have disproportionate asset.
my lord.
So what is the wrong in filing the second FIR?
The second FIR, my lord, the money was already seized in the first FIR, my lord. That is already there on record.
No, disproportionate asset is only with respect to of that money which was recovered in.
My lord, why second FIR, my lord? Why not in the first FIR when the money was recovered?
No, is it only in respect of that money only?
No, it can, yes, only in respect of-
Or your other
No,
income?
no, only that money. Oh, absolutely that money. Nothing more. And that too was not recovered from my house. They alleged that it is your money. Absolutely that money.
Only that bag?
Only that money. Only that money. My lord has got it rightly. Only that money.
Yes, Mr. Sharma, if it is only with respect of that,
So we'll have to examine it, Lordship. Because Lordship, it talks about disproportionate assets of Siddhartha Buragohai, Lordship. It doesn't talk about the last paragraph, if Lordship kindly sees page 48. 48, last paragraph, Lordship will say.
no, read 3, 4.
Yes. Yes. The
Please
then
read.
SP was questioned on the source of such a huge amount of money, except the source money
We,
recovered.
which, while referring to such a huge amount of
Yes.
money, is it referring only to that bag of money or his other?
Only that money, man. Only that.
How much money was recovered
Except
inside
source
that
money.
bag?
64 lakhs, 29,500.
And in respect of the same recovered money, a case has already been charge sheeted.
Hello.
Okay. Please read. 4.
Yes, the recovery of huge amount of unaccounted cash has raised strong suspicion that the accused police officer so-and-so, that the then SP Bozali has accumulated dishonestly and illegally the said disproportionate assets properties other than all his known source of income. There are strong grounds to believe that the accused police officer so-and-so, the then SP Patsala intentionally enriched himself by illicit means during the tenure of his office as the SP Bozali. On completion of investigation, charge sheet against the accused person, namely so-and-so, SP of police, along with 9 other accused person was submitted on 28/11/23 before the court on various charges. Therefore, it is requested to kindly initiate legal action as per the appropriate provision of the land in respect of the disproportionate assets of so-and-so. So, Lordship, it talks about disproportionate assets that may be under investigation, Lordship, if there is any other assets. So at least the
No, my lord,
the
only-
CD may be done for, Lordship.
Only in respect of this bag that
If
was
the
recovered.
CD, Lordship, discloses that it is only within the respect of the cash recovered, Lordship, then there is no.
No, but the acquisition is only with respect of the. It does not, acquisition has not been made
Lordship,
in
but
respect of others.
as far as I can understand, Lordship, it talks about the in respect of disproportionate assets of so-and-so, Lordship. So whether that also has been under investigation, that Lordship will have to see. Lordship will fix a date, Lordship will produce the case. Lordship.
My lord,
Only,
the C-
only regarding, there is some confusion, Lordship, regarding the whether it is only regarding that amount which was seized or whether it is further investigation has been done regarding. his
What is your
other assets.
status?
My lord,
You are on bail.
no, my lord, we are on bail on the first case, my lord.
In second case,
No.
you are not arrested.
Now they are harassing us, my lord. They are now and then coming to our relatives, asking us 100 of questions, my lord. That is the problem. That is why we have come up now. My lord, may see page 42, my lord. Type copy. That is the same amount that was recovered. This is the order of the court below, my lord, in the first case.
Okay. Heard Mr. A.K. Sahewala, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner, namely
Siddhartha Buragohai.
Siddhartha Buragohai, who is praying for quashing of the entire proceedings of CIDPS case number 8/2024, which was registered on the basis of an FIR lodged on 2/4/2024 by one Ariful Haq, Inspector of Police, CID, before the officer in charge of CID Police Station. Learned counsel for the petitioner submits that the aforesaid police station case has been registered on the basis of an FIR, which is in fact second FIR with regard to the same set of accusations made against the petitioner in the FIR, which was lodged by one
Rabiul Islam.
Is
Rabiul Islam.
Rabiul Islam on which
31/8/23.
31/8/2023. The learned counsel for the petitioner submits that the acquisition made in the first FIR is that on 16/7/2023, the petitioner, who was a serving police officer at that point of time, along with some other persons, entered into the house of the informant and assaulted the family members of the informant. And thereafter, where is the accusation of extortion?
That is in the FIR, my lord.
Where? FIR is a big FIR. This bag.
Bag was subsequently recovered by policemen after the FIR was registered.
Stop. And where is the extortion accusation?
Extortion acquisition is, my lord, at page 22, my lord. Last part, my lord.
They again took me back to the one.
My lord, in the middle, they took me to Bhawanipur outpost.
And
10 lakhs cash.
ultimately demanded money from the informant. Whether this was paid?
No, my lord. It was not paid.
We will have to consider also when the charge sheet was filed in that case. Because Lordship, the money was recovered on a later date.
No, my lord, that is wrong. Absolute wrong information. Para 46, my lord.
No, charge sheet kite dichile?
2811.
28/11.
28/11,
Charge
28
November
date, year,
23.
28/11/23.
It was only a case of demand. You have not paid. The
Not paid.
informant had
Not paid.
not paid.
Not paid. It was, the acquisition was against the additional SP. At page 23, down below, thereafter the additional superintendent of police, Bajali, was contacted my brother-in-law. All, my lord, the allegations have come up because they just wanted to suppress the police officers, not to catch hold of them. That was the only acquisition, my lord. Eventually, it was unfortunate that one bag was recovered.
Then where is the error in filing the FIR? If during investigation something has been recovered
So very later date.
on a later date, which gave rise to,
No, my lord. My lord, may come up, FIR दिखा. 5-9 it was recovered, my lord.
5-9 it was recovered, but you have, in the first FIR, there was no accusation that
But
you
in
had
the course of
paid.
investigation, my lord, what the TT Anthony says, it is absolutely in the course of investigation. FIR is not an encyclopedia, my lord.
No, in the course of investigation as regards the accusation which was originally made,
Yes, my lord.
but there is no accusation that you paid the money. You read section 22 of TT Anthony's again.
My lord.
No, para
20 is there,
20,
my lord.
para 20.
The accusation is there, the money was demanded, my lord.
Demanded.
Yes.
It was not paid.
Not paid, it is a matter of investigation, my lord.
No,
Ultimately, that is a matter of investigation. Whether it was paid, not paid, what had happened,
no,
the
but
police recovered.
that was not the accusation. Police recovered later on. That recovery cannot be linked with your in the first charge sheet which was laid. What was the accusation? The recovery of money is there.
Yes, recovery money is there. Recovery money is there, my lord.
Whether
I'll show that, my lord. Recovery of money, exactly that amount was there.
whether that was paid by the
So that is a matter of trial, my lord. Whether that was paid, whether that is the same amount that has been recovered. FIR का copy दिखा, the police type copy दिखा. Page number क्या है? First para. नहीं, तो type copy था. तो तुम type किया था. Police को recover किया. My lord, may come up to page 42, my lord.
read 19 of TT Anthony.
My lord.
Okay. 19 loudly.
My lord. The scheme of CRPC is that an officer in charge of the police station has to commence investigations provided under 156 or 157 of CRPC on the basis of entry of information reported on coming to know that the commission of cognizable offence. On completion of an investigation and on the basis of evidence collected, he has to inform an opinion. He has to form an opinion under section 169 or 170 CRPC, as the case may be, and forward his report to the magistrate concerned under 173(2). However, even after filing such a report, if he comes into possession of further information or material, it need not register a fresh FIR. He is empowered to make further investigation, normally with the leave of the court, and where during further investigation he may collect further evidence, oral or documentary. He is obliged to forward the same with one or more reports. This is important. This is in the import of section 8 of 173.
But it is as regards the acquisition which was first made, it needs, okay. What is the last line? We'll examine that. Informant. Learned counsel for the petitioner submits that during the course of the investigation of the first FIR, a trolley bag containing a cash amount of rupees 64,29,500 was recovered from the possession of the present petitioner.
No, my lord, not from the present petitioner, my lord.
From whom?
Somebody else.
Recovered. Stop. Learned counsel for the petitioner has submitted that after completion of the investigation with regard to the FIR, which was lodged on 31/8/2023, charge sheet has already been laid against the present petitioner on
28/11/23.
On 28/11/23. However, after lodging of the charge sheet, the investigating officer of the first case lodged another FIR on 2/4/2024. Primarily accusing the petitioner regarding recovery of total cash amount of rupees 64 lakhs 29,500 in a trolley, which raised the suspicion regarding disproportionate, which raised the suspicion regarding raised the suspicion as same was disproportionate to the known source of income of the petitioner. Learned counsel for the petitioner submits that as the subject matter of the second FIR is also mainly the recovery of cash amount in the trolley during the investigation of the first case, the lodging of second FIR is barred under such circumstances. He further submits that he cites the ruling of the apex court in the case of T.T. Anthony versus State of Kerala and others, reported in 2001, 6 SCC 181 in support of his submission, wherein the apex court has observed that the scheme of the provisions of the Code of Criminal Procedure is that when no second FIR and consequently no fresh investigation may be launched on receipt of every subsequent information in respect of the same cognizable offense or the same occurrence or incident giving rise to one or more cognizable offense. Stop. He submits that the investigating officer ought to have investigated the acquisition made in the present FIR, during the investigation of the first FIR itself, without filing a subsequent FIR. He submits that in view of the observations made by the apex court in the aforesaid judgment, the filing of subsequent FIR and initiation of a fresh investigation is barred. Stop. On the other hand, learned additional public prosecutor submits that the second FIR has been lodged. It appears that second FIR has been lodged in respect of a different acquisition, that is acquisition regarding regarding the petitioner having disproportionate assets, having assets disproportionate to his known source of income, and therefore there is no bar in lodging of the second FIR. Stop. I have considered the submissions made by learned counsel for the
FIR is of 2424 lordship. Till date, he has not been arrested, lordship. So there is no urgency as such to pass any interim order, lordship.
You're harassing us, my lord.
क्या लिखा let the contentions raised by the learned counsel for the petitioner deserves consideration and needs to be looked into. Hence, let the case diary may be called for. Let this matter be listed on 27th October. However, considering the submissions made by learned counsel for the petitioner as discussed in the foregoing paragraphs, and at this stage, from the materials available on record, it appears that the subject matter of both the FIR appears to be same. Hence, further proceeding of CIDPS case number 8/2024 shall remain stayed till next date of this case. List accordingly.
Grateful, man.
More correct one. Yes.
Must have been petition lost by FIR lost by and divorced wife lordship after almost 12 years of marriage lordship has been challenged and subsequent charge sheet lordship. Page 29 is the impugn FIR and
What has been challenged?
FIR and charge sheet lordship. Page 29 is the FIR lordship.
After how many years?
This is lost after lordship almost 11 years after marriage lordship. Earlier lost some same sort of allegation 498 a trial is going on lordship and file maintenance allowed maintenance is regularly paying lordship. Then subsequently this allegation brought and lordship will kindly see the sections lordship cheating.
What is the stage?
Just a notice issue, summon issue lordship. And fixing 26 for a page and multiplicity of cases lordship. And other CR cases also lost file lordship. India 2024 lordship. Nothing but to harass. He's facing the 498 lordship. I have annexed the order framing charges lordship, page 17. And subsequent maintenance was allowed maintenance is regularly paying without default lordship. Page 18 is the maintenance judgment, final order lordship. Then this FIR loss lordship. And sections are lordship cheating, forgery, and extortion. These sections. Allegation is that the petitioner solemnized second marriage after divorcing her.
Okay.
Being otherwise is regularly appearing in other cases.
Second marriage is barred.
Not barred lordship. And he is Muslim.
You are Muslim.
Muslim. And prohibition of Muslim women from Divorces Act is not also important lordship. Allegation is that I have given Talaka Hassan lordship without following the process. For that part, family court proceeding is there lordship. She can approach that.
What is 318? Cheating.
Cheating lordship.
308?
Extortion lordship. 336 forgery lordship.
What accusation regarding forgery?
Regarding false divorce certificate.
False divorce certificate she is alleging lordship. Where is government Kazi given after 3 talaks of 1 month interval. That is permissible lordship. That is not banned under the prohibition of Muslim.
Otherwise, also he was allowed to go on PR bond.
PR bond is, but only harassment lordship.
PR bond in this case?
In this case, PR bond.
Okay, then we'll examine the
Otherwise, lordship is
heard Mr. M.K. Hussain,
lordship.
learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 528 of BNS has been filed by the petitioner namely Razibuddin Ahmed, impugning praying for quashing of the proceeding of PRC case number 229/2025. Arising out of Moirabari PS case number 1/2025 under section 61 within bracket 2, 318 within bracket 4, 308 within bracket 4, 336 within bracket 3, 117 within bracket 2 of BNS, pending before the Court of Learned Additional Chief Judicial Magistrate, Morigao. Let the scanned copy of the trial court records along with scanned copy of the connected case diary be called for. Let the notice be issued to respondent number 2 by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks, list accordingly.
Kindly stay, Lordship.
No stay. You are on PR bond.
Dear member,
So-
he is facing financial hardship, educated, unemployed here. He is already, Lordship, facing
Only
4
one
cases.
month, only 4 weeks time is given.
Then observation will be, Lordship. Interim will be considered after.
No, this is not a case of interim.
May I please, Lordship? Also, this is a case wherein I was sold a repainted car. My lord, what had happened? In 2020, I purchased one Tata Harrier car. So I had specifically indicated that I need a white color car. So what they did, without indicating me that they have repainted it, they sold me a repainted car. That was a black car, repainted it to white, and they sold it to me. My lord may come up directly. On coming to know about that illegal activity, my lord, I immediately mailed to Tata Motors, my lord. My lord may come up direct to the email, my lord, page 38, annexure 1.
Then what happened?
Then what happened, my lord? I also visited the dealer. They did not support me in any manner. Then I filed an RTI before the RTO, my lord. That is at page 114, my lord, to find out what are the documents that they submitted while getting my vehicle registered, my lord. So to my surprise, I find that
You purchased a new car
absolutely new car. Absolutely new.
from Tata.
Tata Motors, this is the dealer, the Pragati Motors.
Okay. But instead of giving you a new car, they sold a repainted car.
Repainted. Perhaps that time they did not have the white color car. They secretly repainted it and then sold it.
Then what happened? What you are challenging in
Nah, what has happened, I'll come, my lord. Then eventually when we got the report from the RTI, we filed a CR case in 2023 itself. The court took cognizance, issued notices to the accused person.
under
420 and
cheating.
cheating and all that.
Okay.
Eventually what happened then, we also filed one case before the consumer forum. That is also running, my lord. They have already appeared and filed the return statement. Now, as a counter blast, what they did in 24, they filed one CR case against me. That too through my employee, indicating that I want to extort money, just as a counter blast.
Where is that?
That is there at page 22, man. This is the CR case, man.
Cognizance has been taken.
Yes, my lord. Cognizance has been taken, my lord. Cognizance is at page, my lord, 32.
Cognizance taken under what provision?
Under my lord 420 and this one.
Why, on what basis you are challenging this?
My lord, the acquisition that they have brought is that 420 does not come up, my lord, in any point of imagination. And if I had demanded any money in 2021, my lord, they should have filed in the written statement. It should have indicated, just as a counter blast, you come up and file an FIR, CR case before the court, and indicating a statement that no, some money has been demanded, and the court takes cognizance, and I need to.
Court took cognizance only after the statement of complainant as well as
That is also wrong, my lord. I'll come to that because there are two accused, 1 and 2. One is the wife, 2 is the husband.
okay, we'll continue
Mal-
at two.
Two.
At two.
Mal-
At two we'll continue.
Number 1.
For reasons mentioned in the judgment, this revision petition is dismissed. No. No, Mr. Day. I pronounced wrong judgment. Sorry,
Hopefully it is allowed, my lord. In my case.
I thought it to be item number 2. For reasons mentioned in the judgment, this revision petition is allowed, and while upholding the conviction imposed by the trial court, this code modifies the part imposing the sentence on him to the extent that instead of sentencing the petitioners, they are directed to be released on furnishing a bond of, released on probation of good conduct on furnishing a bond of rupees 30,000 each with one surety of like amount to appear and receive sentence when called for during the period of next 1 year, and in the meanwhile they shall keep peace and shall be of good behavior.
Deeply obliged. Item 2.
This one is dismissed for
Item 22.
I'll my
yes.
lordship to page 63, my lord.
No, why this court should invoke its inherent powers?
My lord, I am the
When
partial judge. In the complaint petition, my lord, my lord may kindly come to page 22, my lord.
Yes,
That is the complaint, my lord. No allegation against me, my lord. This is the complaint, my lord, CR 534 of 24, my lord. The next year one. My lord, have got it?
yes.
This was filed in 24, my lord. Now, what it says, my lord? Number 4, accused number.
This you are impugning
No, the cognizance I am impugning.
on
That is
this,
page 32, my lord.
on the basis of this.
Yes, my lord. Basically, I am being cheated, my lord. How can he be cheated, my lord? Somebody sells me a repainted car, and then when I agitate,
Okay.
he comes up.
Heard Mr. A.K. Sahewala, learned counsel for the petitioner. This application under section 528 of BNSS has been filed by the petitioner praying for quashing of the entire proceeding of CR case number 534/2024 pending before the Court of Learned Subdivisional Judicial Magistrate, Jorhat. The petitioner has also impugned the order dated 4/12/2024 by which the cognizance of offense under section
420 and 387 and 34 IPC.
420/387/34 IPC has been taken by the trial court against the present petitioner. Learned counsel for the petitioner has submitted that before filing of the instant filing of the complaint case which is sought to be quashed in this criminal proceeding. The petitioner had lodged a complaint against the complainant,
No, against the dealers, man.
against the dealer. Who is Nishad Nahid?
Nishad Nahid is one of the employees of the dealer, man.
Against the dealer in which the
Nishad Nahid is one of.
Nishad Nahid is an employee. In the complaint filed by the petitioner, it was alleged that the said dealer had cheated the petitioner by selling a old car by repainting it instead of selling a new car to him. Learned counsel for the petitioner has submitted that the present CR case complaint within bracket CR case number 534/24 is a counterblast to the complaint filed by the present petitioner.
Which is numbered as CR 70 of 22.
Your case.
Well.
Within bracket CR 70 of 2022. And it is only for the purpose of harassing the petitioner and wreaking vengeance on him, on her. Petitioner is a lady.
Lady.
Or her. Learned counsel for the petitioner further submits that the trial court also erred in taking cognizance of offences mentioned herein above against the petitioner, inasmuch as the complaint petition does not disclose any ingredient of any offence against the present petitioner. So issue notice to the respondent. Learned counsel for the the petitioner shall take steps for issuance of notice upon the respondent by registered post with AD, as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. In the meanwhile, considering the submissions made by the learned counsel for the petitioner, as discussed in the foregoing paragraphs, further proceedings of CR case number 534/2024 pending before the Court of Learned Subdivisional Judicial Magistrate Jorhat shall remain stayed till next returnable date.
Deeply about.
23.
Make resolution.
Yes.
Well, this petition has been filed for quashing an FIR. May I take your lordship to the FIR first, man?
Yes.
FIR, your lordship will get at page 61. The petitioners before lordship are, my lord, the officers of a company.
61.
Is 61, my 61.
Yes. Yes.
This has been lodged by my lord, SI of police to the officer in charge of police station. With reference to the subject cited above, I would like to inform you that on 13/9/2025 at about 11:30 AM, I received the telephonic information from Sri Withdrawal Kulita, mobile number such and such, regarding a road accident at Jogduar Tiniali NH 37. An oil tanker bearing registration number such and such coming from Sibsagar towards Jorhat had overturned on NH 37 due to rash and negligent driving by its driver. On receipt of the information, I, along with the PS staff, immediately rushed to the spot and found that the tanker loaded with condenser oil lying across the road
after breaking the roadside railing and an electric pole, the oil was spilling onto the road. The Teok fire station was informed immediately, and with the help of a recovery van, the tanker was lifted and brought to the police station. Subsequently, the spilled oil caught fire, which spread rapidly in the surrounding areas. As a result, 3 women sustained grievous burn injuries, namely, my lord, 3 my lord, ladies, and my lord, I am told in the meantime, my lord, 2 of them have, my lord, expired because of the burn injuries. The injured were immediately shifted to the Jorhat Medical College and Hospital for treatment. Later, the fire was brought under control with the help of the fire tender from Tiok, Jorhat, and Sibsagar fire stations. During the course of inquiry, it was revealed that the accident took place due to rash and negligent driving of the oil tanker bearing registration number such and such. Sri Ajit Pandey, son of so and so, district Chapar, Bihar. Further, it was found that the condenser oil was being transported by Oil Max Energy Private Limited, Salenghat Amguri, to MS EPC International Private Limited, Siliguri, without adhering to the proper safety measures. Gross negligence on the part of both the consignor and the consignee company authorities were detected, namely Oil Max Energy Private Limited, my lord, that is the company of the, my lord, the petitioners. The petitioner, my lord, the persons named it serial number 1, 2, 3, and 4 are before your lordship, my lord. They are formed from, my lord, Oil Max Energy Private Limited. Then in view of the above, I request you kindly to register a case against the above named driver, and my lord, this case has been registered under these sections. Now, my lord, my submission before your lordship here is that the 2 companies that has been named in the last paragraph of the FIR, one is, my lord, the Oil Max Energy Private Limited. They are the sellers of the, my lord, the product, and MS EPC International Private Limited, they are the buyers. My lord, there is an agreement. This is a very, very highly volatile substance, and there is an agreement between the parties. And if I may allowed to, my lord, bring to your lordship's notice the, my lord, agreement, the relevant part, my lord, page 24. That will be necessary for your lordship to consider, because, my lord, in deciding the liability. Page 24.
Yes.
This is a, my lord, binding.
No, on what ground you are challenging the affair?
I am challenging this, my lord. Under this agreement, the liability of the petitioner's company is only, my lord, to the extent of, my lord, the loading the substance in the tanker truck provided by the, my lord, buyer. And the moment, my lord, the truck is loaded, thereafter, my lord, it is the responsibility
No,
of
this you can, this information you can share with the IO.
I'm ready to share it, my lord. My apprehension is that because of the, my lord, the death of the 2 ladies, my lord, this has become very sensitive, and they may be arrested at any point of time.
But for arrest, you have some other remedy.
My lord, that may remedy. What I am on is this, my lord. When I place before your lordship, my lord, some my lord, materials which show that the petitioners may not be responsibility, then, my lord, it is your lordship's prerogative, my lord, to consider those.
No, whether powers of inherent powers under 528 can be invoked at this stage,
On that,
unless there is an accusation made against you of negligence.
My lord,
You are mainly apprehending your arrest.
My lord, the accusation is, my lord, that allegation is there, my lord, that we are negligent.
Yes.
But then, my lord,
So that has to be investigated.
My lord, will cooperate with the, my lord, the investigation, because, my lord, the documents, that's why we are trying to place before your lordship, my lord. Those will clear the, my lord, clear the fact.
No, but it is for the investigating agency to.
True, my lord. But then, my lord, when I place, my lord, the substantial material before your lordship to show that, my lord.
No, why this court would go into those facts unless it is not a case where the FIR is devoid of any acquisition. No.
My lord, perhaps.
Now, whether, now my query is whether the accusation leveled against you makes out an offense or not.
True, my lord. But at the same time, your lordship will also consider the materials that, my lord, we place before your lordship to show that, my lord, the affair cannot be lodged against us. Two of the persons they are in Mumbai, my lord. Two of the petitioners are here. And my lord, by no stretch of imagination, my lord, they have got this, my lord, names from the challan and the certificates that we have given.
No, you are mainly challenging the affair, quashing of the affair.
My lord, so far as the petitioners are concerned.
On what ground? That
On the ground that, my lord, my lord, no liability, criminal liability.
no,
can be
for
fixed.
that this court has to go into. You are not submitting that there is no case has been made out, or that it is out of vengeance.
My lord, if your lordship then, my lord, looks into my lord, the sections under which the case has been registered, if your lordship comes to that, my lord, there are, my lord,
Then is it your submission that no case has been made out?
as far as my lord, the sections under which the case is registered, my lord, it does not make out a case against, my lord, the present petitions. More particularly the respondent petition number 3 and 4, my lord. Now, my lord, if your lordship kindly comes to the sections, my lord, under which the case has been registered, under Petroleum Act, my lord, those sections are bailable offences and not, my lord, rightly placed here. If I may, my lord, place the Petroleum Act, I'll place it a little later.
No,
my lord, your
no,
lordship will see.
assuming, accepting your argument
Right.
that these are bailable offences. But
No, my lord, so far as the other sections are, 3 sections are non-bailable. 3 sections are non-bailable under the DNS.
how it helps your case? Your case, you are not arguing a bail application.
No, I am not arguing a bail application. My lord, your lordship knows, my lord, a preliminary inquiry has to be conducted, my lord. Had the preliminary inquiry been conducted, this materials could have been placed before the, my lord, investigating officer. Even now, my lord, we are ready to place those documents so that, my lord, the investigation proceeds.
Okay.
My lord, may I pray, my lord, let the investigation go on.
Yes.
Only thing, my lord, no coercive action should be taken. In the meantime, my lord, we place all the records before them, my lord. With that, perhaps, my lord, ends of justice will be made.
No, but for that you have alternative provisions.
Of filing an application for bail is, my
Bail.
lord, is this there, my lord, but because of the lack of time, my lord, only, my lord, tomorrow and the day after.
No. Yes, Mr.
My lord, in fact, the summons has been issued and they are required to appear tomorrow. Notices have been issued today. They are required to appear before the IO tomorrow, my lord. And that's why I'm making this prayer, my lord. Let them appear, they will appear, my lord.
Okay, already 35 notices were issued to them, that is annexed at page 63. But lordship, the time and again, lordship, the Honorable Supreme Court has held the same view, lordship, that when there is an alternate remedy, lordship, the court should not
Yes,
pass
you
an
have.
order of coercive action.
You are from your submission. What I am understanding that you are mainly apprehending that you may be arrested.
That is true, my
That
lord.
is your main case.
But at the same time, my lord, if these documents are there and if your lordship, my lord, considers these documents, your lordship will, my lord, find that, my lord, no trial, no fruitful trial will be there against the
No,
present
but for interim protection, you have to approach under appropriate provisions.
Only, my lord, that observation, they will, my lord, appear tomorrow. No coercive action till the next date, my lord. In the meantime, they will place all the records before them, my lord. Because the liability is on the, my lord, buyer.
No such observation has no coercive action.
Your
When-
lordship, my lord, for substantial justice, your lordship will make that observation, my lord. Because, my lord, eventually, my lord, even if your lordship goes through the clauses, my lord, my liability, our liability ends the moment that, my lord, the truck is loaded. Truck was loaded on a particular date. It, my lord, moved on the next day. And because of the rash and next day driving, that is what the, my lord, FIR states. The
No,
accident
but
state-
you have approached this court under wrong provision. You have to persuade me to get an interim relief.
My lord,
That I am failing to
to pursue your lordship, my lord, I'd like to, my lord, take your lordship to the, my lord, the clauses of this agreement, my lord, which is binding
No,
on both the parties. this agreement, my lord, that binding term sheet.
Those, please, you can, those information you can give to the.
The IO, I'll provide it tomorrow, my lord. I'll provide it tomorrow before them, but that is the apprehension because of the death of the, my lord, persons who, and there is negligence on the part of the police also, my lord. Because they have not called the, my lord, fire brigade or cautioned the people around that you should not come nearby.
Heard, Mr. I'm not
My lord,
giving.
may I please one decision of the Honorable Supreme Court?
Yes.
If your lordship permits me.
Decision on.
On that, my lord, on exercise of power under 482, of course, my lord, the same power.
Yes.
This is, my lord, your lordship knows there are quite a number of decisions. This is, my lord, 2025 SSA online 1947. The
Para?
relevant paragraphs would be, my lord, paragraph 17 and 20, my lord. In fact, in paragraph 17, my lord, another order of the Honorable Supreme Court has been quoted. Because on perusal of the FIR, your lordship will my lord.
No, in Niharika Infrastructures, Apex Court has observed in an elaborate way that the relief, interim relief of no course of action should not be granted without clarifying what interim.
Because my lord, my prayer is, my lord, to stay the process, my lord, to not to proceed against us, my lord, in the.
No, why you cannot approach under force 82?
Because of the, my lord, lack of time, in fact, my lord.
I'll give you time, you approach. Till that time, I may protect you.
My.
Heard, Mr. M.K. Chaudhary, learned senior counsel, assisted by Mr. P. Bhardwaj, learned counsel for the petitioner. This application under section 528 of BNSS 2023 has been filed by the petitioners, namely 1, 2, 3, 4, name of the petitioners from Yarpal logo. 1, 2, 3, 4, who are praying for quashing of the FIR lodged by respondent number 2, on the basis of which TOC PS case number 119/2025 was registered under section 281/118 within bracket 2/124 within bracket 1/324 within bracket 5 of BNS, read with section 23 within bracket 1 within bracket E within bracket F of the Petroleum Act. The gist of accusation in this case is that on 14/9/2025, one Ganga Fukon, within bracket respondent number 2, lodged an FIR inter alia alleging that on 13/9/2025, one oil tanker bearing registration number NL01A 0959 coming from Shipsagar towards Jorhat had overturned due to rash and negligent driving by the driver, and later on due to spilling of the oil from the said oil tanker, the surrounding area caught fire. Stop. It is also alleged in the FIR that in the said fire, 3 women were severely sustained burned injury. Stop. Later on, out of those 3 women, two women succumbed to their injuries. It is alleged in the FIR that the consignor of the consignor of the oil transported by the ill-fated oil tanker, as well as the consignee were grossly negligent in adhering to the proper safety measures. Stop. Learned senior counsel for the petitioner has submitted that who are you?
My lord, we are the officers of the, my lord, the seller company.
The petitioners are the officers of the seller company, company which sold the oil carried by the ill-fated oil tanker. He also submits that there was an agreement between the
Buyer and the seller.
buyer and the seller, and the liability of seller company was to the extent of
Loading the, my lord,
of the
tanker truck.
only. And he therefore submits that no accusation, no ingredients of offense alleged in the affair has been made out against the present petitioner. Learned senior counsel for the petitioner further submits that the petitioners are ready to cooperate in the investigation and ready to place all relevant documents before the investigating officer. However, he submits that interim protection may be granted in form of a direction that no coercive action may be taken against the present petitioners. On the other hand, learned additional public prosecutor prays for calling of the case diary and submits that for seeking protection from arrests, has submitted that the petitioners have been issued notice under section 35 within bracket 3 of the BNSS. And even if they apprehend their arrest, the petitioners should have approached before this court under appropriate provision of law without seeking invocation of powers under inherent powers under 528 of BNSS. Stop. Learned senior counsel for the petitioner has submitted that the petitioner is ready to approach this court under appropriate provision of law. But as they have to appear before the investigating officer tomorrow itself in terms of the notice issued to them under section 35(3), some interim protection may be granted to them. Stop. I have considered the submissions made by learned counsel for both sides. Let the case diary be, the perusal of the case diary would be necessary for appreciating these contentions of the learned, of the petitioners in this case. Let this case be listed again on 30th of October. 30 October.
But perhaps if the date is long, maybe we will not be able to move a fresh petition, my lord.
30.
That will be shorter date, my lord.
30. No, till 30 I am granting.
13 terronatries. Let the 15th, my lord, after vacation. In the meantime, we can move it, my lord.
15.
Oh.
Let this matter be listed on 15th of Oh,
But
15th,
it is all right. But it is- I thought that I may not be able to approach your lawsuit.
30 October. In the meanwhile, considering the submissions made by learned senior counsel for the petitioner to enable the petitioner to approach this court seeking appropriate relief, the petitioner shall not be arrested in connection with the aforesaid case if they, subject to the conditions that they shall arrested till 30 October 2025, subject to the condition that they shall cooperate in the investigation, list accordingly.
Highly obliged.
Quashing of charge sheet, madam.
Charge sheet.
And charge sheet of proceedings also. Page
Charge-
17 of the FIR. A stranger has filed a case, they're raising the child marriage. And although the fact is that she was major at the time of the marriage, she was a certificate also. Page 17.
Who are the petitioners?
Petitioners are wife, wife's father, my father and myself. Husband, wife. All the four come before us.
Charge sheet has been laid against whom?
Against all, huh? Against three,
Except the
except the wife.
victim.
Who is the victim?
Victim is a four.
Okay. At what stage the charge sheet? The-
Notice now asking for appearance, madam, appearance stage. Appearance stage.
When is the date?
Next date. Asking for nothing. Oh, 39, my lord. Oh, that is earlier. Sorry, madam.
The next date?
October, summer. But kindly see, madam, the judgment to the.
No, we are issuing notice.
No, but in the meantime, for the money, your loss.
Therefore, I am asking what is the next date?
We can collect and we can inform my.
Because on that depends whether
Because they have annexed one order lordship that is of 19/7/23 lordship.
Three.
The first order.
23
First.
lordship. What
no,
has
you
happened-
find out, no. I'm issuing notice. You find out the next date. If next date is long, then there may not be requirement of interim protection. If next date is very short,
Information, my lord, that. But the only question, my lord, whether on the face of the FIR, my lord.
no, I admit,
Yes,
I am agreeable to. But to grant
Once-
interim protection,
yes, my lord.
you have to inform the next day.
But I have made, if I fail to make a case, then your lordship will, my lord. If I have a case, by my face, my lord, certainly I think your lordship will be pleased to grant that here, my lord. On the face, what I have given the 2-3 orders of this one, I will quote my. Of this coordinate bench, my lord, yes. Purely, my lord, it is quashed, my lord, only 2 orders of the coordinate bench, my lord, it was kindness, my lord. And her age, kindness, my lord, her age, my lord. First of all, some age, her age is, my lord, page 20. 20. 20.
The first the FIR.
What is the basis of FIR, my lord?
Yes,
No, he is a stranger, my lord. The BTP secretary, he does not know anything. Victim is with me, 4 years of marriage, I am having a child, we are living happily. There is no complaint from any court.
how old is your child?
Child is 2 years, my lord. 2 years. Birth certificate I have given also, child birth certificate.
No, how will you overcome POXO?
Well, it's not that.
So does not come here, my lord.
Why?
You kindly see my age, my lord.
Okay, what is your age?
Yes, kindly say page 20. Page 20, my lord, page 21.
I'm sorry, lordship, next date is 28/11/25.
Huh? 28?
11/25.
We'll fix it before that date.
Now you'll kindly see, madam, since your lordship already started to, just 1, 2 and exact, then your lordship will decide whatever one. Page 21. Barnacular. It is not a case of POXO, not child marriage. My lord.
No, even if,
Unnecessary.
even if it is not a case, you may not require any interim relief if we fix the date before that next date.
No, interim only because they have already someone notice, yes, next date is there, my lord.
Before next date, we are fixing. Heard Mr. H.R.A. Chaudhary, learned senior counsel for the petitioner, assisted by Mr. J. Abedin, learned counsel for the petitioner. This application under section 528 of BNSS has been filed by the petitioners, namely 1, 2, 3, and 4. Naam likhibo 1, 2, 3, 4. Praying for quashing of the proceedings of POXO case number 131/2023. Learned counsel for the petitioner has submitted that petitioner number 1, 2, and 3 are the accused, whereas petitioner number 4 is the victim of this case. It is also submitted that the petitioner number 3, 4 is the wife of the
Number 1.
petitioner number 1, and no case has been made out against the accused petitioner number 1, 2, and 3, as the victim girl was major when she was married to the petitioner number 1. Issue notice to the respondent number 2. The petitioner shall take steps for issuance of notice upon the respondents by registered post with AD as well as by usual mode. Within 7 days from the date of this order, returnable on 4th of November. Let the scanned copy of the records of POXO case number 131/2023 along with the scanned copy of the connected case diary be also called for. List accordingly.
Obliged.
Will getting the item 27.
Copy, my lord. Should I take back?
Yes, this you can enter it. Item number. Yes,
It's submitted, Lordship.
charge sheet submitted.
Yes, Lordship. Lordship, I have obtained the certified copy of charge sheet.
No, but you approach the trial court.
Lordship, I will approach. So the thing is that, Lordship, since last 81 days I'm behind the bar. I'm at the age of 18 years only. It was my pain and there was love affairs. And by this time, today is first date, fixed before the trial court. Today is the first date. So fixed before the trial court. So by this time, I will file bail application there. It may be rejected, then again I have to approach.
No, why it will be rejected?
Yes, Lordship.
If it is rejected, then you can come.
Yes, again I have to come. So let's say.
But why you are saying that it will be rejected? Why?
If it happens, then I will have to approach Lordship. Yes, my exam is in the next month. I am a student of BA first semester. So it's urgent in nature. This is the main ground of my bail application. So if observation is given, then also it's okay.
Heard Mr. S. Das, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This learned who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid, bearing charge sheet number
158/25 dated 31/7/25.
Since the charge sheet has been submitted, this bail application is disposed of with an observation that the petitioner may approach the trial court and may pray for regular bail before the said court. Learned counsel for the petitioner submits that the petitioner is a student and his examination is scheduled to be held in the next month. The said plea may be taken before the trial court by the petitioner, and if such plea is taken, same shall be given due consideration by the trial court while considering the bail application. Show the presence of Mr. D. Bora, as counsel for respondent number 2.
28.
May please, Lordship. Lordship, in this case, what happened, Lordship? Unlimited. Petitioner was arrested, Lordship, on 25/10/2021 for about 3 years, 10 months, 28 days, Lordship. About 3 years, 11 months. Out of the 10 witnesses, only 2 witnesses examined. And in this case, Lordship, who it is what we do, no? It is as per the seizure list, Lordship, kindly see the page number 20, Lordship. It's the recovery was unclaimed, and Lordship, from my position, nothing recovered, Lordship.
You are the only accused.
The only accused here. Kindly see the page number 20, Lordship.
You are mainly relying on prolonged incarceration.
Mainly on prolonged incarceration, and from my position, nothing recovered, Lordship. TV switch to the.
Which you are relying on some judgments.
Yes, Lordship. I'm submitting.
Yes. Yes.
Lordship, we have to file the objection. The objection we have not received yet. The present petitioner, at the moment, Your Lordship, is involved in other cases as well. So, Your Lordship, objection is necessary. Other case, Lordship, already granted bail. I have annexed the document, Lordship, at page number 49. All the citations there, Lordship, I'm relying the same judgment, Lordship. Page number 49. After hearing, Lordship, after the filing of search, same way he was arrested. Page number 49, Lordship.
You have not prayed for filing of written objection in your first. On last date, no prayer was made.
So, Your Lordship, right now I'm making the prayer, Your Lordship, that we need to file the objection.
You cannot make prayer. Why you fail to make such prayer on your first?
Short date may be fixed, Your Lordship.
We don't have short date. We only have long dates now.
My Lord, page number 49, Lordship.
What is the contraband?
Contraband is, Lordship, ganja, Lordship.
How much?
Lordship, ganja from the truck, from one truck. 200 kg, Your Lordship, ganja. 200 kg. 200 kg. From a truck, which was in abandoned area. From that truck, nothing was recovered, Lordship. Except this, no person was inside the truck.
Okay, heard Miss S.K. Nargis, learned counsel for the petitioner. Also heard Miss R. Hussain, learned counsel for NCB. Learned counsel for the petitioner has this bail application has been filed by the petitioner, namely Achel Al-Sahani, under section 483 of BNSS, praying for 483 of BNSS, who has been detained behind the bars since 25/10/2021 under within bracket for last 3 years, 11 months. In connection with NDPS case number 110/2021 arising out of NCB crime number 23/2021 under section 8C/20B2C of NDPS Act. The gist of accusation in this case is that where is the FIR?
FIR, my Lord, gist of information will, Lordship, at NCB 1, page number 13, Lordship.
that on 1/9/2021, and information was received through reliable sources that, what is your name?
Achalan Sahni.
That one Sandeep will be, that one person, namely Sandeep, will be carrying huge quantity of ganja in a container truck bearing registration number UP 83BT3107. Accordingly, a narco checking was organized and the said vehicle was intercepted. During search of the said vehicle, 207.100 kg of suspected ganja was recovered therefrom. Learned counsel for the petitioner has submitted that the petitioner has nothing was seized from the possession of the present petitioner. And then why are you arrested?
My lord, allegation is that in one number, which was inside the vehicle, one call received that they have alleged that I called on that number. It is
And
mentioned.
he has been arrested only on the basis of a call detail, which is call detail of the arrest. The vehicle was abandoned.
Yes. Unclaimed. It is in the seizure list, it is mentioned.
Call detail from a number received, phone number recovered during the search of the vehicle. She further submits that the charge sheet, the final complaint was submitted against how many accused persons?
Against 3 accused persons,
Five.
two are absconded.
Total 5
Total 3. Lordship will find at page number 27.
against the present petitioner and 2 other accused persons. She submits that the petitioner has been languishing behind the bars for last more than 3 years, 11 months, and only 2 out of 10 listed prosecution witnesses have been examined. He further submits that as the trial is not progressing, hence the fundamental rights guaranteed to the petitioner under Article 21 of the Constitution of India has been infringed in this case. And on that count, he is entitled to get bail in this case. He has cited rulings of the apex court in support of her submission to bring home the point that prolonged incarceration overrides the embargo of Section 37 of the NDPS Act, 1985. On the other hand, learned counsel for NCB prays for filing a written objection. Stop. It appears from the order sheet that on last occasion, when the matter was listed, that is on 3/9/2025, no such prayer for filing of written objection was made by the NCB. Hence, when the scanned copy of the records of the trial court has been received, the seeking of further time for filing written objection appears to be only delay the disposal of this bail application when the petitioner has primarily approached this court on the basis of violation of his fundamental right on the ground of prolonged incarceration. Stop. Quote para 11 from page 52. 12 from page 52, 13. 13 and 14 from page 52. In the instant case also, as the petitioner has been detained behind the bars for more than 3 years, 11 months, which and 3 years, 11 months, and the trial has progressed very slowly as only 2 out of 10 listed prosecution witnesses have been examined. This court is of considered opinion that the period of incarceration undergone by the petitioner may be regarded as long enough to have caused infringement of his fundamental right guaranteed to him under Article 21 of the Constitution of India. And as such, it would outweigh the fetters imposed under Section 37 within bracket 1 within bracket small b within bracket Roman small 1 of the NDPS Act 1985. This court is therefore of the considered opinion that the petitioner is entitled to get bail on the ground of prolonged incarceration. In view of above, which is the court?
Additional sessions of number 5, Kamrup Metro Lordship.
In view of above, the petitioner is allowed to go on bail of rupees 1 lakh with 2 sureties of like amount, subject to the satisfaction of learned additional session judge number 5, Kamrup Metro, with following conditions. Conditions quote from page number 54. A mark kore diso, page 50. This bail application is accordingly dispersed.
Oblige first. 29 for same petitioner Lordship, same way Lordship indicated the person. Lordship, in this case, what happened? The main accused who from whose position it was recovered, he got bail Lordship. That is page number 66. In this case also, he is inside the jail for about 3 years, 10 months, 16 days.
Your Lordship, the contraband here itself is 345.
From the position of the person, Lordship, that is page number 66, he got bail Lordship on 18/6/2025. He has whispered a name that this person, about the person Lordship, about the petitioner Lordship. Because of long incarceration, that court has granted bail Lordship.
Heard Ms. S.K. Nargis, learned counsel for the petitioner. Also heard Ms. S. Hussain, R. Hussain, learned counsel for the NCB. This application under section 483 of BNSS has been filed by the petitioner, namely Sri Achel Al-Sahani, who has been detained behind the bars since 8/11/2021 in connection with NDPS case number 25/2021. Arising out of NCB crime number 19/2020 under section 20B2C/29 of the NDPS Act, pending before the Court of Learned, Special Judge Kamrup, Aminggaon. The gist of accusation in this case is that
Page 11, Lordship.
on receipt of an information through reliable sources regarding transportation of huge quantity of ganja in a truck bearing registration number PB02DV7108, and a Naka checking was organized and the said truck was intercepted. And during search of the said truck, total 345.840 kgs of suspected ganja was recovered from the said truck. How you are connected?
Here, Manjinder Singh, he was the driver of the truck. He has whispered a name, my lord.
Learned counsel
He got
for
it.
Learned counsel for the petitioner has submitted that the petitioner is in no way connected with the offense alleged in the complaint petition. He submits that he was apprehended mainly on the basis of CDR details as well as statement of the co-accused, namely Manjinder Singh, who was arrested in connection with this case. If the learned counsel for the petitioner further submits that in the meanwhile, a coordinate bench of this court has allowed the co-accused Manjinder Singh to be released on bail, mainly on the ground of prolonged incarceration in bail application number 1259/2025 and 2025 within bracket order dated 18/6/2025.
Then page number 5, page number 69, lordship order. In earlier case. I'm relying to Quashing and lordship order. Page 72.
আগৰ কেছৰ পৰা কোট কৰিব লাগিব. I will tell you. 2 lakhs with 2 sureties. I will pass the remaining order in chamber.
Keep your minutes. My pleasure, lordship. Trial court record was called for. The charge sheeted matter, your lordship. FIR is at page number 18.
What is the date of your arrest?
I was arrested on 26/5/2025. It's around 121 days as of today.
What is the offense?
Heroin was seized from me, 165 grams, intermediate quantity. From the vehicle, lordship.
121.
Yes, 121 days.
How? The statutory period is 16.
Charge sheeted matter.
Oh, charge sheeted.
Yes, sir.
Okay. Yes, what is your case?
Lordship, I am a part-time driver. And on the, before, one day before the date of incident of arrest, I went to Aizol to drop a passenger. And while returning to, before reaching Warrant, that is Kachar and Mizoram border, two person signaled me to take them to Silchar. And before reaching Silchar, they received a call. And after receiving the call, they get down from the vehicle at Warranty. And later on at Dhalai, Janata Bazar, I have been stopped by the police on search. Quantity has been, contraband has been seized from my vehicle.
Now what is your submission?
Lordship, I am not
Where do you stay?
resident of Borpeta,
Bongaigaon.
Bongaigaon.
Yes, Mr.
Lordship, otherwise they were arrested on 26/5/25.
No, if he faces trial,
Yes, only thing, Lordship, the vehicle, he was the only occupant, and it was, the contraband was seized from the secret chamber of the back seat, Lordship.
It is alleged that it is secret chamber, but it is found in the back. There is no secret chamber or what.
From the FIR, Lordship, it is clear, Lordship. Otherwise, Lordship, I should not say it, Lordship, but anyway, Lordship, 47 was complied with. 48 notice was given through WT message. They should have pointed that out, but they are not taking that down. I have done.
otherwise, what is the stage of trial?
Lordship, it is for production of the accused person and fixed on 4/10/25.
You are the only accused.
Yes, Your Lordship, at this stage.
165 grams of heroin, Lordship. Some strict condition and let him.
Heard Mr. M.R. Sodial, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner Joynal Ali, who has been detained behind the bars since 26/5/2025 within bracket for last 124 days.
21, Your Lordship.
121 days in connection with NDPS case number 63/2025 arising out of Dhalai PS case number 77/2025 under section 20B2B/29/25 of the NDPS Act. Learned counsel for the petitioner has submitted that the petitioner is facing trial before the Court of Learned
Special Judge
Special Judge Kachar, or with an accusation of possessing how much heroin?
65.
165 grams of suspected heroin. Learned counsel for the petitioner has submitted that the petitioner is the driver of this truck,
No, vehicle, Alto vehicle.
driver of the Alto vehicle, from where the aforementioned contraband was seized. He further submits that on the way from when the petition, on the way from Aizol to Guwahati, two persons took lift in the said vehicle and who after some time got down from the vehicle after getting some phone call. He submits that the contraband seized in this case does not belong to him, and it was of the persons to whom he gave the lift on the fateful day. Stop. Learned counsel for the petitioner submits that the petitioner is a permanent resident of Bongaigaon under Manikpur police station and is ready to face and cooperate in the trial. He therefore prays for allowing the petitioner to go on bail. On the other hand, learned additional public prosecutor opposed the grant of bail to the petitioner on the ground that though the quantity of contraband is seized in this case falls within the category of intermediate quantity, still it cannot be regarded as less quantity, as 165 grams of suspected heroin was seized from the from the seized vehicle. He also submits that the seizure was made from the secret chambers behind the seat of the driver. Secret chambers made behind the seat of the driver of the vehicle. So I have considered the submissions made by learned counsel for both sides. Since this is a case involving offense relating to intermediate quantity of contraband, and hence embargo section 37 of the NDPS Act is not applicable. The trial is also at a very early stage, as the charges are not yet framed.
No, Your Lordship.
As even the charges are not yet framed. Moreover, considering the fact that the petitioner hails from Bongaigaon, if he cooperates in the trial, this court is of considered opinion that his custodial detention may not be necessary for fair completion of the trial of NDPS case number 63/2025. So, in view of above, the above named petitioner is allowed to go on bail of rupees 50,000 with one surety of like amount, subject to the satisfaction of the learned special judge Kachar, with following conditions. Conditions, Munmi Abhishek or Brahmin.
Deeply obliged.
41.
Yes.
Lordship, altogether 3 persons were arrested in connection with this case, Lordship. Palasbari PS case number 274. 2 have been already granted bail by this honorable court, Lordship. And for the 3rd person, Lordship, Baliram Rava, he also approached this honorable court earlier twice. Lordship, the grounds that we have taken in the instant petition that were not taken in the earlier petitions, Lordship, regarding the non-communication of the grounds of arrest. Lordship was pleased to call for the scan copy of the PCR. Lordship, it is there. Lordship. And I've checked the record. Lordship, I have annexed both the arrest memo as well as the notice under section 50 of NDPS. Apart from these 2 documents, Lordship, here I have not found anything which by way of which the grounds of arrest has been communicated to the present petitioner. Lordship. And in these 2 documents also, arrest memo and the notice under section 50, no grounds of arrest has been mentioned. And already, Lordship, the other 2
Where are notice under section 50?
Yeah, under section 50 at page 24, Lordship. Section 50 of NDPS Act. Page 23 is the arrest. And these 2 documents are only available in the record. Lordship. There are no other such materials showing the communication of grounds of arrest to the present case. And 3 persons all are facing trial out of the same materials.
Where is their bail order?
Bail order is at page 64. Annex 964.
Page 64 is not there. You file any additional affidavit?
No, Lordship, page 64,
See,
annexure 9, Lordship.
what is your case number?
Item 31, Lordship. 2912.
41.
31. 2912 BA, Lordship.
This is a wrong case. Page number?
Page number 64, Lordship, annexure 9.
Yes, Mr. Sharma.
Lordship, I have gone through the records, Lordship, no grounds of arrest. In other words, their bail application was earlier rejected by the Lordship. Of course, they did not take that ground.
Yes.
Lordship will find that order at page 53.
Heard. Heard, Mr. Ditul Das. Heard, Mr. Ditul Das, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Baliram Rabha, who has been detained behind the bars since 7/8/2024 in connection with NDPS case number 2/2025 under section 20B2C/29 of the NDPS Act 1985. Quote para 3 from page 65. Learned counsel for the petitioner has submitted that on earlier 2 occasions, the petitioner had approached this court seeking bail. However, on both the occasions, his prayer for bail was rejected. He further submits that this time the petitioner has approached by assailing a new ground that is of violation of his fundamental right guaranteed to him under Article 22 within bracket 1 of the Constitution of India, as he was not informed about the grounds of his arrest at the time of his arrest, when notice under section 50 of the CRPC was served on him. Quote para 5 from page 66. Quote para 6, 7, 8, 9, 10. How much is the contraband?
31 kilo, Lordship, among street, Lordship.
30,000 with one surety of like.
Additional sessions as Kamrup Amingaon.
Yes. A quotation of the Thakibo. Para 10 of the relief asset. Okay.
I'm okay.
Where please, Lordship? 482 application.
Petitioner,
I'm on interim.
Lordship, CD has not been issued. They are already on interim, Lordship.
Interim.
Yes.
City,
Heard Mr. N. Islam.
sixth occasion. Sixth occasion, the city has not come. And it is 182 days already passed.
But you are on interim.
I'm in interim, right?
On next occasion, if they fail to produce CD, we'll dispose it of. Heard Mr. N. Islam, learned counsel for the petitioner.
MHO.
Sorry. heard Mr. M. A. Chaudhary, learned counsel for the petitioner. Also heard Mr. B. Das, learned B. Sharma, learned additional public prosecutor, who prays for some more time for production of the case diary. Prayer is allowed. Let this matter be listed on 31st October. The interim order shall continue till next day.
Obliged.
Item 42.
Lordship, the engaged counsel, Sarfraz Nawaz is on his legs in port 21. May kindly grant a short pass over.
Case diary is there.
For a time being. Here, Lordship, but some instruction was sought for from the forest department. Lordship. They will.
Let forest also come. We'll take it up after some time.
34.
Item
34.
Yes, what is this case? You are for?
Probably they are on interim, Lordship, you cannot go wrong.
None has appeared for the petitioner on call. Mr. B. Sharma, learned counsel for learned additional public prosecutor is present. Miss, what is your name? Miss B. Chaudhary, learned counsel appearing for Mr. K. M. Halloy, learned legal aid counsel for respondent number 2 is also present. Let this case be listed after Puja vacation on a date to be fixed by.
I may be allowed to send back the civil. Lordship.
On a date to be fixed by registry. On 30th of October, the case diary may be sent back to be called again after updation.
45.
May it please your lordship. In this matter, my lord, we are reading by Mr. K. N. Chaudhary, senior advocate. My lord, he is on legs, my lord. The matter may kindly fix tomorrow, my lord. An interim order till today, my lord.
Yes, Mr. Kotaki.
There is available. May I pray one thing? Well, 43, same case diary, same FIR, my lord. And I am on interim till today. My lord, let it come after vacations.
You are opposing?
After proposal,
After vacations, my lord.
we are opposing by the. There's some incriminating statements are there, my lord. Because they don't fall into the criteria, my lord.
So we'll fix it after vacation.
After vacation, my lord.
Heard Miss R.S. Devri, appearing on behalf of Mr. T. Devri, learned counsel for the petitioner. In item number 35.
43, no?
In item number 43, heard Mr. A.K. Bhuya. Separate order hobo of similar nature. Heard Mr. A.K. Bhuya. Also heard Mr. P. Kotoki, learned special public prosecutor, who has produced the case diary. On request of learned counsel for the petitioner, let this matter be listed after on 30th of October. 30th of October. The case diary may be retained, may be sent back to be called again after updation. The interim order shall continue till next date.
46.
The case diary was called for and a petitioner is on interim. So the PD has not been received.
Heard Mr. D. Talukdar, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who prays for some more time for production of the case diary. Prayer is allowed. Let this matter be listed on 4th of November. The interim order shall continue till next.
Chief Lordship, but we'll have to update the CD Lordship. It's not updated.
Lord,
They are
you am-
already on interim.
Heard, Mr. What is your name?
Appearing on behalf of
Eighth-
DK Agarwal.
Interim, appearing on behalf of Mr.
DK Agarwal.
D.K. Agarwal. D.K. Agarwal. Also heard Mr. B. Sharma, learned additional public prosecutor, who prays for some more time for production of an updated case diary. The prayer is allowed. Let this matter be listed on
Lordship, my
4th
interim, I'm on interim.
of November. The interim order shall continue till next date.
Much of that.
49.
Charge sheet submitted, Lordship.
Mayor, the petitioner is in interim, my lord, granted by your lordship.
Mr.
Check, my lord.
E. Sheikh, learned counsel for the petitioner, who submits that the petitioner was granted interim bail
By the order.
by order dated 5/9/2025. You have appeared,
Yes, my lord, appeared.
and in person to the directions of this court, he has appeared before the investigating officer and has cooperated in the
Yes, my
investigation. On the other hand, learned additional public prosecutor submits that the charge sheet has been laid in this case, bearing charge sheet number.
Charge sheet number 61. Dated 20/09/25.
Stop. In view of the submission of charge sheet, as well as in view of the fact that the petitioner has complied with the directions of this court, the interim bail granted to the petitioner by order dated 5/9/2025 is hereby made absolute with conditions. Condition number 1 and 2 attached to the said order, Roman 1, Roman 2, attached to the said order remaining intact. This anticipatory bail application is disposed of.
Highly obliged.
40, 41 and 42. Okay, here also they are on interim Lordship. CD has not been received, Lordship.
The petitioner has appeared in statement recorded, lordship.
Heard, Mr. Nambilak Divo, AR Shom in 40. Item number 40, AR Shom. Miss M. Bora in item number 42. And Mr. M. Alam for item number 41. Also heard Mr. B. Sharma, learned additional public prosecutor, who prays for some more time for production of an updated case diary. The prayer is allowed. Let this matter be listed on 4th of November. The interim bail granted to the petitioners shall continue till next date.
Obliged, your lordship.
Item number 9.
Sorry, Vinod, I could not be present when the matter was called. May it please the Lord. The petition application seeking, my lord, quashing of the charge sheet and cognizance order, my lord. Now, the petitioner before lordship, my lord, he is a practicing advocate of this honorable court. Now, what he did, my lord, as a panel advocate of IDBI Bank, my lord, he prepared a charge report, my lord, which led to the initiation of the criminal matter. And initially, my lord, he was asked to appear before the investigating agency appeared. But subsequently, my lord, he has been shown as an accused. Now, the brief facts are like this, my lord. In all 6.
Now at what stage the
Now, this stage is, my lord, on 10th it is fixed, my lord.
Or-
Cognizance has been taken.
or charge?
Only summon has been issued. Copy is not yet, as per my
Appearance.
knowledge- No, appearance, only
Ah.
appearance. First appearance. Copy is not yet formed. So only after copy inspection, then charge will come.
So therefore I should wait till then.
No, I am not. Lordship has asked for the state.
Yes,
It is
yes,
in my
yes,
knowledge, I
yes,
am apprising.
yes.
That is not the issue.
Now, my lord will kindly come to the charge sheet straightway, my lord. Now, what is the allegation against me? Lordship will kindly have a look. Page 62, my lord.
Yes.
Three Abhijit Bhattacharjee, by this title investigation report dated 4/12/2009, opined the bank about documents required for creation of mortgage against the question collateral securities. He opined that the mortgage property 8540 square feet land and commercial complex in the name of Srimati Muli Devi Saraugi situated at village Kamekha under Mauza Jalukbari in the district of Kamrup, comprising Dag number so-and-so of KP Patta number is clear, marketable, transferable.
When is the next date fixed?
10th of October.
Okay.
And
To deal with the parawise reply.
and bank may create a equitable model. I'll satisfy your lordship's, my lord. There is absolutely nothing in this case, and there is a judgment of the Supreme Court, my lord. A lawyer who gives an opinion who cannot be roped in like this. The mortgage properties in the name of the Otis Associates Private Limited, Srimati Rumi Jalan and Narayan Deka, situated at village Borkhozai under Moza in the district of Kamrup, comprising Dag number so-and-so, is clear, marketable, transferable, and bank may create equitable mortgage over the aforesaid plot of land. In all the above reports submitted by Sri Bhattacharjee, it is mentioned by him that discussions I had with the mortgager, this is absolutely incorrect, whereas Muli Devi Saraugi had expired during submission of his legal report. Moreover, Sri Rumi Jalan and Narayan Deka have stated that Sri Bhattacharjee had never met them during the legal charge of these properties. In all the title investigation reports, he mentioned that landed property is free from all encumbrances from 1987 to September 1998. Due to non-completion of index beyond September 98, the authorities are not in a position to provide up-to-date status. Hence, that means Milord petitioner suggested IDBI Bank to obtain original affidavit of non-encumbrance for the borrower grantor. But although he was not sure about the non-encumbrance of the properties offered as a collateral security mortgage, he mentioned in the title investigation report dated 4/12/2009 as under. Plot at Borkhozai in the name of Narayan Deka. Mutation record reveals that the aforesaid landed property stands in the name of Narayan Deka and property offered in the mortgage is in possession of the applicant. So similarly, my lord, he refers to the his view in respect of the sixth report. Now, para 16.24. It is mentioned here that although the above mentioned properties, serial 1 and 3, were sold out in October and November 2009 as by Srimati Nirmala Devi Kashliwal to others on the basis of GPA executed by Narayan Deka and Rumi Jalan, Sri Bhattacharya certified that the properties are in possession of the applicant. The same certification was also given with regard to property of Srimati Muli Devi Saraugi mentioned at serial number 4 above, although she expired on 23/6/2009. Well, they have taken exceptions to two things, my lord. This lady who mortgaged her property, Muli Devi Saraugi, my lord, she expired on 23/6/09. If that information is not given to me, how do I find, my lord? Is it humanly possible that Narayan Deka and Rumi Jalan sold their land, my lord, unless the Jamabandi still reveals the name of the original pattadars? My lord, what had happened in this case, just to appreciate the my lord position, if your lordship would kindly come to page number, form. Yes, my lord will kindly come to page number 92, my lord.
Page number 92. My lord, this is not a document relatable to this case. We have annexed it just to show by way of an illustration how it operates. Name of applicant Sri Ramananda Rabha certified that properties indicated below have been charged in the office record from 87 to July 98 and found the following results. Up to that record is not ready due to non-completion of index work. Therefore, petitioner said, you take affidavit from the mortgagors that their property is not encumbered or whatever it is. My lord, if the, my lord, when we as a lawyer also have given my lord charge.
What is the offense which is
Yes.
alleged against?
Now the offense is stated to be under, my lord, section. One second, my lord. Yes, offense is under 120B, 420, 467, 468, 471. Well, I do not know what forgery I have committed, my lord. My lord, certain papers are forwarded to the lawyer. Normally, one who appears for the bank and all, my lord, they often insist on a charge report. Now, what the lawyer does, he says that get a charge report from the sub-registry's office for the last 12 years. Now, when the report itself says that it is not updated, as a lawyer, what he can do, my lord, after seeing the revenue records, where in Jamabandi name is shown, he can also say, yes, he is in possession. Now, does it invite any criminal action, my lord? That's the point. Now, what Supreme Court said, my lord, here it's a very simple case, my lord. The charge report given by the Deputy Commissioner's establishment was not up to date. It was up to 98. Therefore, he said, please insist on an affidavit from the mortgager that the property is not encumbered. Now, I'm relying on two judgments of the Supreme Court.
Who says so?
My lord.
That to obtain the affidavit.
The petitioner.
Yeah,
That is what is recorded in the, my lord.
to whom he is advising?
To the bank, my lord. If a lordship would kindly come to page 62 for a moment. The charge sheet part, my lord.
Yes.
Okay. Line about 6 from the line about 4 from the bottom, my lord. After referring to that thing that it is only up to September 98. Hence, he suggested IDBI Bank to obtain original affidavit of non-encumbrance from the borrower guarantor. My lord, the police who investigates, my lord, they also have a responsibility, my lord. You can't see everything with a jaundiced eye. You should also behave like a human. You must have some empathy. You must think of consequences of ensuing a criminal proceeding. My lord, what is now in these circumstances, what the Supreme Court says, I'll place two judgment, my lord.
What is the accusation against other accused, co-accused person?
Others also, as it, my lord, they have naturally 120B is there. And 420 cheating. And my lord, fact of the matter is, in this case, the entire amount has been liquidated. Entire amount. That's why, my lord, Supreme Court, I'm relying upon two judgments of the Supreme Court, where, my lord, this view has been taken. If a lordship would kindly have, প্রদীপ হয় না প্রদীপ কেস নিয়ে কি হবে থাকে কিন্তু তুমি আকৌ এইটো কৰি আছো Milord will first have the judgment, Milord. Milord, CBI versus K. Narayan Rao, Milord. This is 2012, 9 SCC 512. If a lordship would kindly come to para 27. Para 27. However, it is beyond doubt that a lawyer owes an unremitting loyalty to the interests of the client, and it is the lawyer's responsibility to act in a manner that would best advance the interest of the client. Merely because his opinion may not be acceptable, he cannot be molested with the criminal prosecution, particularly in the absence of tangible evidence that he associated with other conspirator. At the most, he may be liable for gross negligence or professional misconduct if it is established by acceptable evidence and cannot be charged for offense under section 420 and 109 IPC along with other co-conspirators without proper and acceptable link between them. It is further made clear that if there is a link or evidence to connect him with the other co-conspirators for causing loss to the institution, undoubtedly the prosecuting authorities are entitled to proceed under the criminal prosecution. Such tangible materials are lacking in the case. Here in this case, my lord, the entire loan has been repaid. There is no loss, financial loss to the bank. This is one. Then, my lord, the other judgment which I am relying, my lord, if a lordship would kindly have the judgment, that is K. Bharati Devi versus State of Telangana. I'll refer to two paragraphs, paragraph 7 and 58. Now, para 7 for appreciating the facts, my lord. It is further submitted that during pendency of OA before the DRT, in view of OTS, an amount of 3 crore 80 lakhs was paid to the respondent to bank, and as such, the respondent number 2 bank has closed the loan account. The learned senior counsel therefore submits that continuance of the proceeding against the appellant would be an exercise in futility. This was the submission, my lord. Please come to para 58. At page 17. Where the High Court quotes
58.
Para 58 at page 17.
58, there is no.
58 is a quotation of another judgment.
In which para?
At page 17, Miller. At para 23. Where the High Court quashes a criminal proceeding, having regard to the fact that the dispute between the offender and the victim has been settled, although the offenses are not compoundable, it does so as in its opinion, continuance of the criminal proceeding will be an exercise in futility, and justice in the case demands that dispute between the parties is put to an end and peace is restored. Securing the ends of justice being the ultimate guiding factor, no doubt, crimes are acts which have harmful effect on public and consist in wrongdoing that seriously endanger and threatens the well-being of the society. And it is not safe to leave the crime door only because he and the victim have settled the dispute amicably, or that the victim has been paid compensation. Yet certain crimes have been made compoundable in law with or without permission of the court. In respect of serious offenses like murder, rape, dacoity, etc., or other offenses of mental depravity under IPC or offenses of moral turpitude under special statutes like PC Act or offense committed by public servant while working in that capacity, the settlement between the offender and the victim can have no legal sanction at all. However, certain offenses which overwhelmingly and predominantly bear civil flavor, having arising out of a civil, mercantile, commercial, financial partnership, or such like transaction or offenses arising out of matrimony, particularly relating to dowry, etc., or family dispute, where wrongdoing is basically to the victim, an offender and the victim have settled all disputes between them amicably, irrespective of the fact that such offenses have not been made compoundable. The High Court may, within the framework of its inherent power, quash the criminal proceeding or criminal content or FIR if it is satisfied that on the face of such settlement, there is hardly any likelihood of the offender being convicted or by not quashing the criminal proceeding, etc. Well, this judgment is perhaps for the proposition, my lord, even in cases which are not compoundable, depending upon the nature of the case, my lord. High Court at times in a given case can, my lord, invoke power under 482.
If it is predominantly civil,
My lord,
if it is of predominantly civil nature.
yes, correct, my lord. My lord, if your lordship to kindly come to page 59 for a moment, my lord.
59
Yes,
of
page 59, part of the charge sheet, my lord. Para 16.14.
what was the main acquisition?
Main
FIR.
In the FIR, my lord, the main acquisition was, my lord, that the loan was taken and it became NPA. Therefore, my lord, to protect the, my lord, actually we came to know about the death of this lady, my lord, and that the Narayan Deka and Rumi Jalan, that they sold their land in the DRT proceeding. They initially, my lord, went to DRT bank for recovery. Now, if a lordship would kindly come to, as I was referring to, my lord, page 59, para 16.14. Investigation established that the said CC account of Otis Private Limited has been closed through on 29/10/24. Borrower had paid the entire loan outstanding amount as OTS amount, that is 3.10 crore, and delayed interest of 11 lakhs. Apart from the OTS amount, bank has also got the auction price of 89 lakhs by selling one of the collateral securities of the borrower. Since the loan account of the borrower is closed, withdrawal petition has been filed by the bank in the DRT. So as in the second case which I placed, my lord, where there also, my lord, pursuant to an OTS given by the bank, the loan was defrayed, my lord. Therefore, Honorable Supreme Court took the view that it will be an proceedings in futility, therefore it should not be proceeded with. Now, my lord, what is my fault, my lord? I, as an advocate, I gave an opinion when the charge report from the Revenue Authority was not forthcoming in the full form. I said, you take an affidavit, but then borrower takes the responsibility. If there is anything wrong, then how can I be roped in, my lord? End of the day, my lord, in a criminal trial, my lord, all these allegations, intentions has to be proved beyond any reasonable doubt. And where is the scope? There is no outstanding dues. I, as a lawyer, I perform my duty. That's why Supreme Court says, my lord, in an appropriate case where there are materials, of course, you can proceed. It's not an absolute bar. But then it all depends upon the facts of each case. And in the charge sheet itself, it reflects that I instructed the bank to obtain an affidavit because the revenue reports are not complete. And tomorrow, my lord, if I do not give the report, then bank cannot give the loan. If the loan cannot be given, how does bank survive, my lord?
The accusation against you is that you gave the title investigation report
irregularly, inappropriately, irregularly. Now, my lord, what is that? My lord, supposing, my lord, if that is the situation, supposing, my lord, I'm giving an extreme example. It so happens sometimes, my lord, some orders are passed by administrative authorities, judicial authorities. On appeal or revision, it is found that orders are wrong. Will it entail a criminal prosecution, my lord? It's a very serious thing, my lord. That's why Supreme Court says that when you take this step, then you must have a foolproof case. That's why, my lord, many times it is said, yes, whether as a lawyer, if you commit a misconduct, then your matter should be referred to bar council or something, that's a different thing. But I don't think a criminal prosecution can ensue for this, my lord. Ample submission is, my lord, there are other materials are also there. I'll satisfy your lordships at the time of hearing, my lord. For the present, my lord, the continuance of the proceedings against me is an abuse of the process of law. Therefore, I'll respectfully pray, my lord. The proceeding against the petitioner should be stayed, my lord.
How many petitioners, how many accused persons are there?
11.
11. Whether the trial court would be able to proceed against other accused persons?
Yes. Lordship will not take long time, my lord. Let them come up with their responses. Lordship can decide the matter after vacation.
It cannot be. And moreover, in the PC Act, there is no provision of a stay. It has been already given. And the Supreme Court is
I'm not a government servant.
in a number of cases where the economic offenses are involved, it cannot be stayed. It is 19, I'm coming to the, and I'm coming to the ruling also, Your Lordship, and as of now, we
No,
have not.
their
allowed
submission is
trial.
that acquisition under PC Act is not against the present petitioner. As because he is not a public,
Servant.
he is not a public servant.
But there is a certain ruling that if the court officer is there, if he is appointed by the bank, it is deemed to be a public servant.
What is the next date fix?
10 million.
So I'm coming to the 19C.
10th October.
And I'm coming to the, this is a very big judgment with regard to the Peace Act and
File written objections.
no. That is with regard to the stay, when stay can be given, when the power of 482 can be exercised in the PC Act and economic offenses. This may kindly be seen in the last before granting any stay. And moreover, section 19C, 3C clearly says, it is also distinguished there in the judgment also. No court shall stay the proceeding under this act on any other ground, and no court shall exercise the power of revision in relation to any.
We are issuing notice at this stage.
Yes, only notice has issued. They will get ample chance at
My
this stage.
appearance on 10th may be dispensed. Milord, it's a, I think,
But you are a lawyer,
that's why, Milord.
or your appearance may not be difficult.
No, Milord. Lordship, here is a case, Lordship will kindly, my Lord, I think we have been able to make out a prima facie case for your Lordship's kind consideration, Milord.
You have to make
No,
a,
no, what is my, let my learned friend say, make submission, other than Supreme, Milord, the judgment is an authority for what it actually decides. Every sentence in a judgment is not to be read like a statute.
heard Mr. K. N. Chaudhary, Learned Senior Counsel, assisted by Mr. S. Paul, Learned Counsel for the petitioner. Also heard,
Stage only prima facie matter will go, we cannot try.
also heard Miss M. Kumari, Learned Standing Counsel, Learned Special Public Prosecutor, CBI. This application under section 528 of BNSS has been filed by the petitioner, namely Shri Abhijit Bhattacharya, praying for quashing the proceedings of special case number 20/2025, qua the petitioner as stop. The said case is pending before the Court of Learned Special Judge, CBI, Additional Court number 3. Stop. The petitioner has also impugned the order dated. You have impugned cognizance order also.
Yes.
Order dated 5/8/2025, passed by Learned Special Judge CBI, by which cognizance of offense under section 120B/420/467/468/471 of the IPC was taken. No cognizance under PC Act has been taken.
It is the stage when the summon has been issued and thereafter the charge, there is no charge here.
No, but the cognizance has not been taken under PC Act.
It is based on the charge sheet. Yet to be charged, that,
No,
that
no.
opportunity.
Charge sheet.
Charge sheet.
The charge sheet was laid under provisions of PC Act also.
Yes.
There is nothing below. What the petitioner, there is no allegation.
Where is the cognizance taking order?
at page number 94, my lord. Your attendance is necessary to answer a charge under section 120B 420. Page 94.
It is only a summary. only.
Someone. And the
And page, man,
impugn order whereby the cognizance was taken.
I'm coming at page number 89, your lordship. This court take cognizance of the offence punishable under section 120B, 420, 467, 468, 471 IPC.
Only IPC of.
IPC offense, para 8,
So if cognizance is not taken under
PC Act.
PCI,
So that will be decided at the time of,
no, unless cognizance is taken, unless you challenge the cognizance taking order, how charges can be framed without taking cognizance? Under,
at the charge stage, there is a provision that any section can be added, deleted also. That will be decided at the charge stage, because before that, it is not possible to do the mini trial only at, even at the charge stage, charges are framing on the basis of the prima facie case. And at the last stage, the charge can be altered. Charge can be altered at any stage, and that stage has not yet appeared as of now. We need to file reply and it is premature.
last line. Learned senior counsel for the petitioner has submitted that no ingredients of offense under which cognizance has been taken is there against the present petitioner. Stop. In the charge sheet, the accusation against the petitioner, who is an advocate by profession, is regarding furnishing of a title investigation report dated 4/12/2019 2009 by the petitioner without making proper inquiry regarding the fact as to the properties in respect of which he had issued title investigation report were actually encumbered or not. Learned senior counsel for the petitioner submits that the petitioner has only performed his professional duty, and in performance of his professional duty, merely because his opinion may not be acceptable, he cannot be roped in a criminal prosecution. Stop. Learned counsel for the petitioner submits that the petitioner, while giving the title investigation report, also suggested to the IDBI bank to obtain original affidavit of non-encumbrance from the borrower/guarantor, which itself shows that he did not had any mens rea in committing the offense alleged in this case. Learned counsel for the petitioner submits that as the prosecution side has failed to make out a case against the petitioner, make out a prima facie case against the petitioner under those section under which the cognizance has been taken in this case. The criminal prosecution qua the present petitioner is liable to be quashed. On the other hand, learned special public prosecutor has submitted that at this stage, notice may be issued and some time may be granted to the petition, to the CBI, to her to obtain necessary instructions in the matter. She further submits that in the meanwhile, no interim protection should be granted to the petitioner, as there is a statutory bar under section 19 within bracket 3 of the 19.3 within bracket C 19.3 within bracket C of the Prevention of Corruption Act 1988 regarding grant of interim stay during the pendency of any proceeding under the said act. So I have considered the submissions made by learned counsel for both sides. On perusal of the materials on record, it appears that accusation against the present petitioner in the charge sheet has been mainly in respect of the professional opinion which he had rendered to the IDBI Bank in his capacity as in his capacity as panel advocate of the bank. Stop. Further, it also appears that the no cognizance of any offense under Prevention of Corruption Act 1988 has been taken in this case by the learned special judge Assam. Stop. The contentions raised by learned senior counsel for the petitioner in this case deserves due consideration. Hence, let the notice be issued. Since Ms. M. Kumari has appeared for the Central Bureau of Investigation, no formal notice need to be issued to respondent number 1. As regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice upon the said respondent by registered post with ID as well as by usual mode within 7 days from the date of this or November of the first week. Returnable on 4th November. Stop. In the meanwhile, however, considering the fact that against the petitioner, no accusation under PC Act has been made and the accusation against him is mainly for giving improper legal opinion while acting as penal advocate of the IDBI Bank in view of the judgment of the apex court in the case of, in view of the observation made by the apex court in the case of CBI Hyderabad versus K. Narayan Rao, reported in
2012, sorry, 2012 9 SCC 51.
2012 9 SCC 512. 512. That
Para 27.
that a lawyer may not be roped in a criminal prosecution merely on the basis of legal opinion rendered by him in absence of any other tangible evidence associated any other tangible evidence that he has associated with other conspirators. Stop. The further proceeding of special case number 20/2025, qua the present petitioner, pending before the Court of Learned, Additional Learned Special Judge, CBI Additional Court number 3, shall be stayed till the next returnable date. List accordingly.
Proceeding will be futile at
Lord,
this stage.
court
because we
had
have
some
not able to file reply also.
Learned,
Milord, 4th had some difficulty. Could it be either 31st or Milord 11th? Milord?
on 11th of November, Learned Special Public Prosecutor CBI has also prayed for allowing the CBI to file a written reply in this case, which is allowed. Same may be done
Proceeding will get stayed.
on the.
So thereby it will get delayed. That is also
You
another-
have options after passing of the orders, you have other options.
Deeply alright.
Much obliged.
Ordered item 44.
My pleasure, Lordship. Lordship, my career is now out of vacation, my lord. So matter may be fixed after vacation, my lord.
44.
Yes, my lord.
What is your name?
R.I. Via, my lord.
Heard Mr. R.I. Bhuya.
On behalf of NA's mother.
You are also engaged counsel. Has submitted learned counsel for the petitioner, has prayed for an adjournment on the ground of personal difficulty of the engaged counsel. The prayer is allowed. Let this matter be listed. You are appearing for Mr. What? Mr. S. Tarabdar. A. Tarabdar has appeared for respondent number 4. The prayer is allowed. Let this matter be listed after puja vacation on a date to be fixed by registry.
It may be fixed, my lord.
Let registry fix the date.
Item 45.
Obliged.
Actually, due to some personal difficulties, my senior could not appear.
Any interim is there?
No interim.
Okay, heard Mr. M. Rahman, learned counsel appearing on behalf of Mr. N. Ahmed, learned counsel for the applicant. Also heard Mr. S. Das, learned amicus curiae for respondent number 2, as well as Mr. B. Sharma, learned additional public prosecutor. Learned counsel for the petitioner has prayed for an adjournment. वो dictate किया है क्या पहले? First line. Prayed for an adjournment on the ground of personal difficulty. Prayer is allowed. Let this matter be listed after Puja vacation on a date to be fixed by registry.
Hello.
May I please? So that we have taken the steps regarding the sole respondent. Let us release the maintenance of pendant like lawsuit. And but office note shows that service is not completed.
We'll wait. Heard Mr. N. H. Loskar, learned counsel for the petitioner. The office note dated 22/9/2025 shows that the service report in respect of notice issued to respondent is still awaited. You'll take fresh step or should we await?
Wait,
Await further. Let this matter be listed after Puja vacation on a date to be fixed by registry.
it's a date lawsuit on 23-24 May be lawsuit, October lawsuit.
Let this matter be listed on 24th of October.
Highly obliged.
Hello, the service awaited. Hello.
Will you take fresh steps or should we await? Heard Ms. N.S. Thakuria, learned counsel for the petitioner. On perusal of the office note dated 22/9/2025, it appears that the service report in respect of the notice issued to sole respondent is awaited. Await further. Let this matter be listed after Puja vacation
Can it be on 15, my lord?
on 15th of October.
Obliged, ma'am.
48.
May I please, your lordship. Your lordship, in this matter, service with regard to respondent number 1 is still available, your lordship.
You will take fresh steps or heard Miss
R. Begum.
R.
Begum.
R. Begum, learned counsel for the petitioner. It appears that also state is a party.
Yes, your lordship.
Also heard Mr. B. Sharma, learned additional public prosecutor. It appears that notice service report in respect of notice issued to respondent number 1 is still awaited. Stop. In view of the office note, comma, the petitioner is directed to take fresh steps for issuance of notice upon respondent number 1 by registered post with ID, as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks.
Date may be fixed.
Day 6th November. List accordingly.
49. Wait, so IFO condemnation of delay, Lordship. 1295 days of condemnation.
What is the matter?
It's about, Lordship, kindly peruse page number 58, Lordship.
What is the case?
Lordship, the judgment is at page number 13, Lordship.
Who is the party? State or?
State is the party and the one private respondent is here.
Okay, we issue
It's
notice.
okay, Lordship.
Issue notice to the.
Actually, the matter of fact is that the record was misplaced and we have explained the reason.
What is
and
the
also
first? Okay, heard Mr. What
US
is your
Bora.
name?
US Border, Lordship.
U.S. Bora,
Bora.
learned counsel for the petitioner. This application under section 5 of the Limitation Act 1963 has been filed by the applicant Nitul Soikia, praying for condoning the delay of 1295 days in preferring the connected civil revision petition, criminal revision petition, by which the judgment dated 20/11/2021 passed by learned Additional Session Judge Golaghat in Criminal Appeal number 17/2019 has been impugned. issue notice to respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on 3rd of November.
May it please your lordship. This I is for suspension of sentence, lordship. What had happened, lordship, the petitioner had preferred a criminal revision petition, lordship, against an order of an appellate court, lordship, when he was convicted for 6 months, lordship, in an NI case, lordship. Amount already paid to the respondent, lordship.
Amount paid.
Lordship, amount has already paid, Lordship.
Then you compromise the matter.
Lordship.
Then first we will condone the delay.
Lordship, delay already condoned. He has appeared there, delay already condoned, lordship. This I is for suspension of sentence, lordship.
Why to suspend sentence?
Lordship.
This criminal revision petition may be disposed of
Lordship,
on compromise.
lordship. That may be disposed of, lordship.
Okay, disposed of. I will pass orders in chambers.
Lordship.
You have that agreement.
Lordship. I have one, lordship, that not agreement, not done, lordship, money received. I have.
Where is the main case? Where is the written? You may file a application compounding compounding the offense.
Lordship.
Now, the offenses are compoundable at any stage. You may file an, I'll fix another date. Instead of, we are suspending the sentence till that date.
Lordship.
Whether the trial court has issued any processes against
Lordship, trial court has issued NBW against me, lordship.
if he is not pursuing, why trial?
No, lordship, after issuance of NBW, then thereafter compromise has been made, lordship. And he, payment already made, lordship.
Okay, then we'll pass orders in the main case.
Lordship.
Heard in main case. Heard Mr. P. Bordole, learned counsel for the petitioner. Also heard Mr.
M. Alam.
M. Alam, appearing for the sole respondent. It is submitted at bar by the learned, submitted at bar that both the parties have arrived at an amicable settlement between them, as the fine amount imposed by the trial court has already been paid by the petitioner to the respondent. Learned counsel for the respondent submits that the respondent intends to compound the offense, and for that some time is prayed for filing an appropriate application. The prayer is allowed. Let this case be listed on 28th of October. However, in the meanwhile, as learned counsel for the petitioner has submitted that the trial court has already issued non-bailable warrant of arrest against the petitioner. Stop. The said non-bailable warrant of arrest issued against the petitioner shall not be executed till the next date of this case. It is further directed that the execution of sentence imposed on the petitioner by the trial court shall also remain suspended till the next date in view of the facts and circumstances of this case. List this matter accordingly.
I dispose of.
This is in the main case. You can withdraw.
Be allowed to withdraw the
I heard Mr. P. Bordole, learned counsel for the petitioner. In view of the orders passed in the criminal revision petition number 384/2025, he seeks leave of this court to withdraw the instant interlocutory application. If prayer is allowed. This IA interlocutory application is disposed of on withdrawal.
Lordship. Oblige, your Lordship.
May I pledge your Lordship? Lordship, this I is for condonation of delay for 690 days, Lordship.
Who is the other side?
Lordship.
State.
No, Lordship, it's a private person, individual.
Heard Ms. T. Begum, learned counsel for the petitioner. Also heard learned counsel for the petitioner. This application under Section 5 of the Limitation Act 1963 has been filed by the petitioner, namely Syed Ali, praying for condoning the delay of 688 days in filing the connected criminal revision petition, whereby the petitioner has impugned the ex parte order dated 21/6/2023, passed by the learned Judicial Magistrate First Class, Goalpara, in DV case number 206/2020. Stop. Whereby 2020, whereby the petitioner has been directed to pay monthly maintenance allowance to the respondent and her two minor sons, as well as compensation amount also. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by registered post with ID, as well as by usual mode, within 7 days from the date of this order, returnable on fixed date, 3rd of November.
I did 52.
None has appeared for the petitioner on call. Let this case be listed after puja vacation on a date to be fixed by registry.
Please, your Lordship. Lordship, this is an IA for condonation of delay in pertaining to criminal revision petition against the order dated 30/4/2025. Lordship, kindly allow the notice to be issued to the.
Heard Miss.
That is it.
Heard Miss L. Izum, learned counsel for the petitioner. This application under Section 5 of the Limitation Act has been filed by the petitioner, namely Dr. Khan Ashraful Alam, praying for condonation of delay of 49 days in filing the connected criminal revision petition. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by registered post with ID, as well as by usual mode, within 7 days from the date of this order, returnable on 3rd of November.
54.
Here I am challenging the ex parte of any ex parte order, my lord, under section 125 CRBC, my lord, and on the basis of the ex parte in IA file regarding NBW issued against me, my lord. ex parte order, my lord, in
What is your prayer?
my lord, oh, my lord, my prayer is, my lord, during the pendency of this petition, my lord, NBW may issue the
No, no, you appear before the,
my lord, that is why to, my lord, already final order was passed in the,
when is the date?
my lord, that was, my lord, on 2/7/24, my lord, final order was passed, ex parte final
No,
order.
next date when you have to appear. In a NBWA, a date has been fixed. Or where is that order?
My lord, only another date, my lord, last page in IA, my lord.
When is the next date fixed? In execution case?
In IA, last, my lord, already another date, 38/25, already, my lord, gone, my lord.
No, unless you are able to,
At least I have to,
you find out we are issuing notice. Or you appear before the executing court.
my lord, I will appear, my lord, that, I will appear, my lord. But for that also, my lord, the NBW,
When will you appear? You don't know when you have to appear.
my lord, oh, my lord, before, my lord, next date, my lord, though I have not, or I have.
What is the next
On
date?
one, my lord, on one will give chance.
Heard Mr. M. Hussain, learned counsel for the petitioner. This interlocutory application has been filed by the petitioner, praying for suspension of NBWA issued by the executing court against the petitioner in execution within bracket criminal case number 24/2024 in connection with FC criminal case number 568/2023. Stop. Learned counsel for the petitioner submits that petitioner has preferred a connected criminal revision petition whereby he has challenged the ex parte order passed in FC criminal case number 568/2023, whereby he was directed to grant maintenance allowance to the respondent.
Next, page 2, my lord.
Stop. The petitioner submits that, learned counsel for the petitioner submits that the petitioner is ready to appear before the executing court within a period of a month from the date of this order, and therefore prays for suspension, prays for staying the execution of the non-bailable warrant of arrest issued against him. Stop. Issue notice to the opposite party. The petitioner shall take steps for issuance of notice upon the opposite party by registered post with ID as well as by usual mode within 3 days. By tomorrow you take notice.
Okay.
If you want interim,
My lord,
by tomorrow.
my lord, day after tomorrow, my lord, I may not be able.
Within 2 days from the date of this order. In the meanwhile, to enable the petitioner to appear before the executing court within a month from the date of this order, in the interim, the non-bailable warrant of arrest issued against him by the court in execution criminal case number 24/2024 shall remain suspended till 24 September 2020, 24th October 2025. List accordingly.
Item 55 from supplementary list.
Please, Your Lordship.
26 clears.
26, na? 26. It's connected, number 26, my lord. So they've been listed in admission method, my lord.
What is this?
I am, my lord, for bail, for suspension of sentence and bail, my lord. Original method,
26.
appeal, my lord. Appeal 371, my lord.
Delay, no?
Delay. Two appellants, my lord. Both have been convicted under section 4 of POCSO Act, as well as 313 of Indian Penal Code, my lord.
This is
More
this-
than 10
this-
years, my lord, notice has to go and
10 years, my lord,
10 years.
with fine, my lord.
Okay, heard Mr. S.
we'll
Gogoi,
also file objection. my lord.
learned counsel for the petitioner. This application under section 430 of BNSS has been filed by the applicant Zakir Hussain in connection with criminal appeal number 371/2025, praying for suspension of the execution of sentence imposed on the applicant by the impugned judgment. Stop. Learned additional public prosecutor submits that the state intends to file written objection in this case, and for the same he prays for some time. The prayer is allowed. Issue notice to respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice upon respondent number 2 within 7 days from the date of this order, returnable on 3rd November. List accordingly.
Two I am, my lord.
Two I am, my lord.
Both the I am.
One more eye.
My lord, one I have, item 55
26.
is Zakir Hussain
Thank you.
and item 26 is Ator Ali.
This is item number. Earlier one
26.
was
Item 55 is connected with that, my lord, appeal, my lord.
item, it is also same eye,
Same,
same order.
Same order.
Item number 26, same order.
2 persons, my lord.
2%,
different-
my lord.
Petitioner silo or nam silo. In appeal,
Appeal is over there, my lord. Two appellants, my lord. Appellant number 1 has been convicted under section 4 of POCSO Act.
in item number 26. This,
Yes, Two appellants, my lord.
this appeal under section 415 of the BNSS has been filed by the petitioners, by the appellants, namely
Zakir.
Zakir Hussain and Ator Ali, impugning the judgment and order dated 8/7/2025, passed by learned special judge Lakhimpur, North Lakhimpur, in POCSO case, in special POCSO case number 146/2018, whereby the petitioner number 1, whereby the appellant number 1 was convicted under section 313 of the Indian Penal Code, as well as under section 4 of the POCSO Act, and was sentenced to undergo rigorous imprisonment for 6 years and to pay a fine of ₹6,000 under section 313 of IPC with default stipulation. And he was also sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of rupees 8,000 under section 4 of the POCSO Act with default stipulation. The appellant number 2 was convicted under section 4 of the POCSO Act and was sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of rupees 6,000 with default stipulation. This appeal is admitted for hearing. Issue notice to the respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice within 7 days from the date of this order. Call for the records of the trial court. Registry to take steps for requisitioning of the records. List accordingly.
Leave the president.
Right, please, Your Lordship. Statutory appeal was convicted under section 12 of the POCSO Act and sentenced to 1 year's imprisonment.
Heard Mr. S. Nawaz, learned counsel for the petitioner, learned counsel for the appellant. This appeal has been filed under section 415 of the BNSS by the appellant, namely Johur Ruddin Dewan alias Johiruddin Dewan, impugning the judgment and order dated 8/9/2025 passed by learned Special Judge POCSO Sirang in Special POCSO case number 24/2024. Stopped by the impugned judgment, the appellant was convicted under section 12 of the POCSO Act and was sentenced to 12 and section 12 as well as under section 75 of the BNS and was sentenced to undergo rigorous imprisonment for 1 year and to pay a fine of rupees 10,000 and in default of payment of fine to undergo further imprisonment for 1 month. No sentence was imposed, no separate sentence was imposed under section 75 of the BNS. This appeal is admitted for hearing. Issue notice to the respondents. The petitioner shall take steps for issuing, the appellant shall take steps for issuance of notice upon the respondents within 7 days from the date of these orders in pursuant to the prevailing notification of the registry in this regards, returnable on 3rd of November. Let the records of the trial court be requisitioned. Registry to take steps for requisitioning the record list accordingly.
I am for previous bail, I'm already on bail, 1 year imprisonment.
The interlocutory application, this interlocutory application has been filed by the applicant under section 430 of the BNSS, praying for suspension of the sentence imposed on the appellant by the judgment and order dated 8/9/2025 passed by learned Special Judge POCSO, in POCSO Sirang in Special POCSO case number 24/2024. Stop. The aforesaid judgment has been impugned by the applicant by preferring the connected Criminal Appeal number 370/2025. Learned counsel for the petitioner has submitted that since the sentence imposed by the trial court is for a short period, short term of 1 year only, unless the execution of the sentence imposed is stayed during the pendency of the connected criminal appeal, the criminal appeal itself may become infructuous. Stop. Since you are on
I'm already on bail.
previous bill. Stop. I have considered the submissions of learned counsel for both sides. Since the sentence imposed on the applicant by the impugned judgment is for a short-term period of 1 month or 1 year only, the execution of same is suspended during the pendency of the connected criminal appeal number 370/2025. The applicant is also allowed to remain on the previous bail granted to him by the trial court. This interlocutory application is accordingly disposed of.
Perhaps, my lord, time, that is that red sandalwood matter, my lord, and also special PP wildlife is not there. It's been pending for a very long time.
Let him appear. Let him come after.
After vacation, my lord,
After
there is no time also.
Heard Mr. S. Nawaz, learned counsel for the petitioner. It appears that none, though the name of, you are appearing?
No, my lord, forest department is required, my lord, otherwise.
Yes, though the name of learned special public prosecutor forest department is reflected in the cause list, none has appeared. In view of the above, let this case be listed again.
My lord, in the meantime, we will update the CD, my lord.
On 28th October, 22nd October, the case diary which is available with the learned additional public prosecutor may be sent back for updation to be called back again after updation on the said day.
I beg to apologize, Your Honor. So I went to NCLT.
What was your case number?
52. One is for condonation delay, another is for 1 year punishment.
Today, my lord, only delay part because it is not numbered.
52.
Yes, Lord.
9 days. 9 days.
9 days only.
First we will have to condone the delay. You are opposing?
9 days delay, my lord.
Dr. B. N. Gogoi, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor. This application under Section 5 of the Limitation Act has been filed. Delays of 277 days.
9 days.
9 days, Your Honor.
9 days.
Only 9 days.
Which matter?
83797. 52. There's a 2 IA.
IA number 1069.
83975. 1069, yes. Lord.
1069.
Oh, yes.
You have stated in your application that 277 days delay.
So I beg to apologize. So it's only 9 days.
9 days.
Your petition, it is 9 days. Before me,
Typological error, yes. Only otherwise 9 days.
In my petition also.
Jayanta Das, by hand you have corrected it, or registry has corrected it.
Statutory
1 year.
Revision 1 year, I don't have objection on.
Who has made it? Who said it? You verify.
Lordship.
if it is 9 days, we will allow it.
No, it is wrongly been typed. It's just nine days. In our paper and all that registered, all them they said 9 days. 9 days, your lordship, because the judgment has been passed on, your lordship.
Who made that correction?
12/8/2024.
Registry given notice.
Nothing, your lordship. That is
Then who made that correction?
my
please?
junior perhaps, your lordship.
You verify
Yes,
and
it is
make a
9 days.
correction. No,
I will-
unless you make the corrections.
I will correct it. I undertake, your lordship. Only 9 days, your lordship, because for 1 year and he has already been, in the meantime, he has been arrested. 10 months gone, 10 months left.
Copy of the order sheet first. Order
It is passed on, your lordship, 12/8/2024, judgment and order.
What is the date of judgment?
Judgment on, your lordship, original judgment was passed on, thereafter we have filed in a district court also. 12/8/2024, your lordship.
No, 12/8/24.
Thereafter, the CGM court has passed an order dated on, your lordship, is on 12/8/2024. Date of judgment, your lordship. It pays 35.
12/8/24.
12/8/24, then it will.
It will be 277
It is
days.
more than 9 days. It will
Well,
be more
that's
than.
it. Then thereafter, we have filed one, the district court, judge.
Where is that judgment?
That is there in the order that.
What is the order of
The annexure 1, your lordship.
page number?
Annexure 1 is the copy of the order of 12/8/24.
Yes.
Subsequent to that, annexure 2 perhaps, showing the date.
Thereafter, we have filed in district judge.
You verify it,
Got
then we'll take it up
Lot.
after rectification. If it is urgent, we will take it up day after tomorrow. On request of learned counsel for the petitioner. Let this matter be listed on 26th. Day after tomorrow or after vacation?
Vacation it will be hard. Thereafter, tomorrow.
The day after tomorrow, that is on 26th. 26 September 2025. The petitioner is also allowed to rectify any defect if noticed in the condonation of delay application. List this matter.